Good afternoon, everyone, and welcome back. I hope you enjoyed your lunch break period. We are going to jump right back into the topic of conversation we were on at the conclusion of the morning session, which is PSLF sub-article 5. But before I turn it over to Jen, just to briefly reintroduce the topic and solicit questions and comments, I just want to briefly announce that Will is here subbing in on behalf of FEL agencies. And we have John representing individuals with disabilities or advocacy services representing them. So with that, Jennifer, do you want to briefly reintroduce PSLF Article 5?
Sure. We already jumped into the discussion, but this, put simply, we're clarifying the definition of full-time employment. And Aaron had some regulatory text up that he's pulling. Yep, there we are. And that is the pertinent section that we are already discussing.
Thank you. And so we'll pick back up right with the folks who had their hands raised when we went off camera. So Suzanne, the floor is yours for 3 minutes.
Sure, thank you. So I'm actually putting on my lecturer hat because I have personal experience being an adjunct here. So yeah, I concur with Jerry that 2.5 is not going to be enough. I understand that the department's going to want a basis for whatever number you pick. My question would be, maybe of the advisors, is there research on average hours worked? For the prevalence of adjunct instruction, I would think there might be some data out there that we could look to come up with a better number about, how much work goes into teaching a credit hour. So that would just be a suggestion there. And then also in terms of how to certify, I have also heard, from my UCAFT colleagues that it can be very difficult to get these things certified. And I do wonder if maybe, since course information is published, is there a way that an instructor could, provide copies of their course offering to demonstrate that they were teaching? Just a thought for how to self-certify employment generally. And then my last point, which is just a small wording thing, would be that I do think that I think there's variations depending on institutions about the kinds of terminology used. So one suggestion would be to use contingent or non-tenured faculty, and I can put that in the chat just to record it. Thank you.
Great, most appreciated. And then Marjorie, you were next. You still? You're good. Okay, thank you. And then so we're at Heather.
Thank you. So I would just want to reiterate some of Jerry and Suzanne's points, as well as the public commenter as it relates to contingent, adjunct, non-tenure, part-time, whatever other name, faculty at less than full-time status may be referenced. And I think the certification piece is something to think about, because many of those faculty are also engaged beyond the classroom with the institution in other ways. Some of them do engage in committee service. Some of them are providing professional advising services to their institutions, and often that is beyond the contractual agreement that they may have in terms of providing courses for the institution. So I certainly think that there are some worthy pieces embedded in all of the comments that have been made so far, and I just wanted to lend to that.
Thanks, Heather. Bobby, you've got 3 minutes. Go ahead.
I just want to perhaps add one more small piece for consideration. For graduate students or graduate research assistants or teaching assistants in STEM fields, a lot of times they, as they're pursuing a master's or a PhD, they'll fall below half-time status as they're conducting research for the institution. And their loans may kick in at that time. And is there a space for us to perhaps consider a calculation for those individuals?
Thanks, Bobby. Ed, do you feel you have enough on this to move to temperature check to TA regulatory text? Yeah, I'm seeing nodding heads. Okay, so Aaron, if you could briefly unshare the document. Thank you. And then if everyone could, the old standby, show thumbs. Agreement, can live with, strong disagreement, and we're just getting a read of the room right now. I'm starting to see folks. All right, I am seeing a number of thumbs down. And as per usual, so I know that folks have voiced some substantive issues they have with the text as proposed, but does anyone want to succinctly add any new objections that they feel have not been adequately raised or that are not yet captured in chat? Dixie, yes.
Yeah, so I wanted to take the moment to ask Raj if he could pull some research into workload of adjunct professors, and then also seeing how many campuses they have to travel to, and if also possible, travel times between those, because that's also part of the workload that adjunct professors and guest lecturers take on. And so, yeah, Suzanne had mentioned it, but I just wanted to reiterate that and also add in just publicly so that Raj could pull that information for us. I don't feel comfortable without having that section and having that data and research about the workload that adjunct professors and guest lecturers take on.
Sure, thank you. Raj, do you have that data prepared? I'm not seeing him in the room right now. So we might just need to table that, an outstanding data request, but we will return to that once we have him. Jennifer, please.
I was just going to say Raj might be tied up right now for making preparations for the IDR remarks we've asked.
Yeah, I know we're going to call on him later for additional presentations, so he might be wrapped up in that. But Daniel, final word on this, but then we're tabling this, I'll make a note of it, and then once we have him back in the room, maybe he can speak to this.
Thank you. Dixie brought up a point that I had not considered until she raised it. The other question is adjunct who are teaching at multiple institutions and whose work in total brings up full-time. And it brings up the issue of full-time work as at one institution versus multiple work that adds up to full-time that might in fact all qualify. So I just want to echo that as we can reconsider this, we look at the impact of multiple gig jobs or multiple jobs that all qualify that could in fact not be on their own full-time, but in total are respective as full-time.
Thank you. And I see Suzanne mentioned that, but if you just want to make it explicit in the chat just for the transcript. And then Dixie, I see your hand, but I also see Raj did just post in chat. Do you want to briefly restate the request to him in case he missed it? And then Raj, feel free to come on camera if you feel prepared to present on this.
Yeah, so that's exactly what I was going to do. So Brady, good job. You got me. So I was just going to ask for Raj if he could pull up any research and data on the workload adjunct professors and guest lecturers take on, with the added information about travel times between multiple campuses, guest lecturers, and adjunct professors because that's also part of their workload. And I wasn't comfortable with, having, with moving on without that data and information, especially as within the CSU, the Cal State University system, which I attend, we have tons of adjunct professors and guest lecturers, most of which are people of color and people with tons of student loans, student loan debt. And so I really want to take into consideration that data and information point, and even in specific, because most of my professors are adjunct professors. And so I really want to have data and research on their workload.
Thanks, Dixie. And just as a reminder for folks who might be listening in, Professor Raj Darolia is an advisor for this committee on behalf of economic and/or higher education policy analysis and higher education data. So Raj, feel free to unmute and the floor is yours.
Yeah, so actually for this topic, what I might ask is that you give me some time to go and search and get this information. So I think it's a great request and certainly one I'm happy to go seek out and find the best information for. I don't have it on hand right now, but I'll make a note of it and I'll alert the mediators if I can get it tomorrow. If not, we'll do it in advance of the November session.
Great, I appreciate that. And then Dixie, again, just be very, the data request in chat, just so we can refer back to that. Thank you. So picking right back up, I saw a lot of thumbs down, but any additional comments or additions that we want to be sure to discuss or surface prior to moving on to issue paper number 9? All right. Oh, Michaela, please.
Yeah, on here it says that for full time, it means working and qualifying, employing in one or more jobs. Does that not, I just want to make sure that I'm not misunderstanding if that made it so that it does allow for that kind of compiling, or is there a separate concern that folks are having around that piece of it?
Since I raised it, if I can respond, my issue is, yes, Heather pointed that out and I appreciate that in the chat. My particular concern is the issue of adjunct faculty and the fact, again, that to Dixie's point, with travel time, et cetera, that there may be additional needs around adjunct faculty and considering multiple employers. That was my point.
And for me,
yeah,
oh, I'm sorry. And for me,
please.
it's the calculation is inaccurate for getting adjuncts credit for PSLF.
Got it. Thank you again, everyone, for that. And Jennifer, I think we are ready with that issue spoken about to move on to issue paper number 9.
Great. Thank you, Brady. So this is issue number 9 of the issue papers. Aaron, if you could pull up issue paper number 9, we do have some proposed regulatory text associated with this issue. It is with regard to pre-dispute arbitration and class action waivers. To summarize, we found that institutions may use arbitration clauses in their enrollment agreements effectively to discourage students from pursuing complaints. This enables institutions to avoid financial risk associated with its wrongdoing and shift the risk to taxpayers and the federal government through subsequent borrower defense discharges. Furthermore, due to these enrollment agreements, borrowers cannot have their day in court because these waivers prevent their ability to participate in lawsuits, including class action litigation, further insulating institutions from potential financial risk and wrongdoing. Finally, there's just an overall lack of transparency surrounding institutions' arbitration requirements and limits on class actions. And our authority to prohibit these arbitration clauses and class action waivers is in section 454A6 of the HEA, which authorizes the secretary to include in the program participation agreement, quote, provisions that the secretary determines are necessary to protect the interests of the United States and to promote the purposes of the direct loan program. Again, similar history with many of the rules we're negotiating. We added a prohibition on these agreements and waivers in 2016, but in 2019, we rescinded those provisions. And so now we're proposing to prohibit direct loan participating institutions from using certain contractual provisions regarding dispute resolution processes and to require notifications and disclosures by institutions regarding their use of arbitration. So firstly, we're proposing to restore the prohibitions that were in place in 2016, again, to prohibit institutions from obtaining, through the use of contractual provisions or other agreements, a pre-dispute agreement for arbitration to resolve claims brought by a borrower against the institution that could possibly form the basis of a borrower defense claim. So that's one prohibition. Secondly, we propose restoring a prohibition for institutions to obtain an agreement to waive a borrower's right to initiate or participate in a class action lawsuit regarding such claims. And thirdly, we propose to require institutions to notify the department and to disclose to students the institution's use of arbitration and to provide judicial and arbitral records to the department, which will be shared with the public. And the proposed regulatory text is largely what we used in 2016 when we first prohibited this exercise.
All right, we will jump right in. First up, we have Josh, who is speaking on behalf of legal aid organizations. Josh, all yours.
Thanks. I'll start off by saying that the legal aid community appreciates the restoration of this provision. It is essential to keep the courthouse door open to borrowers. Like Michelle on Tuesday, who in public comment said that the degree she had was, quote, not worth the paper printed on. And then we think these regulations are a step in that direction. With that said, there are 3 specific ways where we don't think these proposed regulations go far enough. First is with respect to the requirement to provide arbitration and judicial records to the department. What we found in practice is that schools dispute what constitutes a borrower defense claim as to trigger that requirement. And so rather than define borrower defense with respect to this provision, with respect to the borrower defense regulation, we would suggest that the department just more broadly define a borrower defense claim as any claim alleging an unlawful act or omission by the school. That way, the department and the public have access to when schools are trying to compel arbitration. Second, I don't think the proposed language goes far enough when it comes to enforcement. I'd like to see some sort of automatic trigger or automatic language requiring enforcement of these provisions if a school violates them. What we found with respect to the 2016 regs is that schools included languages in their contract that did not mirror the regulatory language and instead pegged their obligation to whatever regulation was in effect at the time. And so we think it's particularly important that these regulations compel the department to enforce them. And then the final area where I think that the regulations could potentially go further and where we'd be interested in hearing whether the department has explored this is with respect to other lenders or other situations that have become more commonplace in post-secondary education. So for instance, we would be interested in seeing this proposal extended to private lenders that an institution essentially forces a borrower to borrow from, or to cover things like income share agreements, which are becoming increasingly more utilized. So with those 3 changes, this could be a really strong and meaningful regulation. And as I started, we do appreciate the restoration of the
30 seconds.
Language.
Thanks, Josh. Jessica.
Sure, thank you. Proprietary institutions respectfully disagree with the department on this solution. We want to stress up front that transparency and taking the time to educate the student is clearly crucial. We don't want that to get lost. And when done correctly, arbitration is often a more efficient and less adversarial means of dispute resolution than time-consuming and expensive litigation that may result in borrowers waiting years to obtain a fair hearing and any relief. Arbitration may also allow borrowers to get greater relief than they would in a consumer class action case, and federal policy favors arbitration. With disclosures on admissions web pages in the admissions section of the catalog, discussion during the enrollment process, and published clearly defined steps to file an arbitration claim, students can make informed decisions about enrolling in an institution that requires pre-dispute mandatory arbitration agreements and class action waivers versus those who do not. And also, even if a borrower signs an agreement for pre-dispute arbitration, the borrower has access to the department's borrower defense process. The borrower may file a borrower defense application before the arbitration begins, during the arbitration, or after the arbitration, as long as the borrower otherwise meets the requirements for submitting a BD application. Borrowers also have access to other complaint systems, including FSA feedback complaint system and the VA Principles of Excellence complaint system, that are always available to them regardless of the school's use of arbitration agreements. Proprietary institutions' goals are much like the department's goals for the regulations we are negotiating. Schools want to offer a more efficient and effective process for both students and institutions.
Thank you, Jessica. I'm just going to read out the folks that I have in line right now. We have Josh, Justin, Jerry, David, and Joe. We'll start with you, Josh.
Thanks. I see a lot of hands behind me, so I'm just going to focus on this idea that arbitration is a more efficient means for students to get relief. Now, it's more efficient because students don't have access to discovery in arbitration and so aren't getting the records that the school has that a student needs to pursue their relief. It's more efficient because precedent doesn't usually matter in arbitration. So students don't have to spend the time with their lawyer finding the right case in the right jurisdiction to make sure that their claims are actually adjudicated under the proper law. It's more efficient because a student generally doesn't have a right to appeal in arbitration. Unlike the court system where there's review by upper bodies, there's no such right in arbitration. It's more efficient because you're dealing with an arbitrator who wants repeat business and across industries typically favors industry rather than consumers. The idea, it's more efficient because borrowers don't even know that a pre-dispute arbitration clause is included in their contract. One study found that in 2015, less than 9% of surveyed consumers understood that an arbitration clause was included in their contract and what impact that would have on their ability to go to court. Finally, it's more efficient because the students and consumers more generally don't generally bring arbitrations because it's not friendly to consumers, because it's difficult to navigate, and because sometimes the relief is so minimal that the only way to actually get relief is through a class action in court. For instance, a 2019 study found that while there are 825 million consumer arbitration clauses in consumer agreements, there are about 7,000 arbitrations per year. So this idea that it's more efficient to go the arbitration route for students and that in any way protects students is simply false.
Justin.
Yeah, thank you so much. I just want to say that we appreciate the department's proposal here to restore this prohibition. But quite simply, we don't think that students should be forced to bargain away their day in court. I know there was some discussion of other complaint systems that exist. For instance, I think there was specific reference to the VA complaint system or the GI Bill feedback tool. That is true that that system exists, but it's no substitute for the legal process that should be available to students. So I'll leave it there for now. Thank you.
Thanks, Justin. I'm seeing Jennifer's hand as well.
I just wanted to be sure, Josh, if you have any proposed language on the first 3 points that you made, you could drop those in the chat. That would be great.
Sure. So we don't have any yet, but I'll prepare some and circulate it later on.
Thank you.
All right, Jerry, I believe you're up.
I'm going to remember to put my hand down this time. Okay. I'm a first generation student. I would walk into the admissions office so pleased I could go to college. I would sign away body parts. I think I've made that clear. I would sign stuff I don't even remotely understand to be able to attend college. And I think the process that was described does not protect me at all as a student because I don't know. I don't have the, and I don't have the means to know unless I stumble upon it or stumble into a legal aid office and it sounds like I would be giving away more than I got and I would just be walking away. It's too much paperwork. It's too frustrating. Like apparently I must be the idiot because I didn't understand what it meant to be an arbitrator if all of a sudden my school closes. I just think I'm so happy this is going back in because I think that anything less than that is just a detriment to students. You know, we talked yesterday about web pages that may not be updated. We talk about, you know, all these means that students don't pay attention to the paperwork they get, but we can't have it both ways. And I just think that without this clause, it's a pure detriment to any first generation student, anyone who doesn't have somebody guiding them through a process.
Thanks, Jerry. David, you're recognized.
Yeah, SHEO strongly supports this proposal. Our members are in the position of trying to advance the public interest and the public good and student success, and this is critical to it. I personally, I see one of the primary roles for agencies like the U.S. Department of Ed and their regulatory powers as being to address existing inequalities within the systems that they regulate, to correct for structural problems and to address bad actors. We don't make policy on the best case scenario. The best case scenario is great. We make policy to address where problems exist, where structural things keep back certain groups of people and students. I really appreciated Jerry's comments. I was in a similar position where, and so many, probably the majority of underrepresented students, students of color, minoritized students, and many others are in the same position where they have no idea what arbitration is. They didn't read it. They're just damn happy to be there. And yet, in so many cases, they get screwed. And then to not have a legitimate path for recourse just compounds that. It perpetuates the inequalities. And that's exactly what we're supposed to be preventing. Making policy on the best case scenario perpetuates inequality, and we can't do that here.
Thanks, David. Brian, I see you popped up. Did you have a response to a previous comment?
No.
Oh, okay. Sorry about that. Then we'll move on to Joe.
Hi. Thanks for recognizing me. First off, I want to say that we support bringing back this ban on pre-dispute arbitration clauses. As somebody who helps to run one of the complaint systems that Jessica mentioned, I can say that although we do our best to mediate consumer complaints that we receive against proprietary schools, we are not a substitute for the legal process that we believe students are due. I can also say that the volume of complaints that I receive against for-profit schools are far more than my office has the resources to prosecute. And we are helped when students can help themselves. When students can enforce their own legal claims, it brings accountability to the sector and helps to promote a fairer marketplace, which is in line with the goals of State Attorneys General. I want to address a specific question that Josh raised, and that's on the issue of enforcement. And I think, and this may be slightly off base, but I think what Josh is saying is that there could arise situations where the school doesn't put the provisions or amend their agreements as they're required to do here. And I've spoken with private counsel regarding the 2016 provisions. And one of the problems that came up was the ability for the student to bring an action without that action being dismissed by the court where the amendment hadn't been made. And in particular, it arose, I believe, and Brian may be able to illuminate this a little more, but I believe that these are included as part of the school's program participation agreement. And to the extent that the school is either no longer participating in Title IV or the example I'm thinking of is a school that has announced that it's going to close and students bring claims against that school. Is there a way to structure this? I don't know if there is, where the student would be able to not have to have the department enforce that provision, right? So that the department doesn't have to say, no, school, you didn't comply with your program participation agreement, that the borrower can go to the court and in a very clear and efficient manner say, I have the right to bring this case. You should deny the motion to dismiss.
Thanks, Joe. Appreciate your comments. John.
Thank you. Just very briefly. Defendants always want arbitration. I think it's important to note the comments of Jessica on behalf of the proprietary institutions in that light. Nursing homes, credit cards, pushing for arbitration is and has been long a goal of defendants. We know that arbitration is better for institutions. It is not better for students. And let's not be mistaken about what's at stake here. This is about the balance of power. And we fully support the department's decision here to revert to the 2016 provisions subject to the expansion or caveats made by Josh. Thank you.
Thanks, John, and thanks everyone in chat who's agreeing and adding additional comments. Heather, please.
Thank you. And this is, I think, more of a question for Jennifer than anything. In some of the narrative under solution, there are references to contacting accrediting agencies. And I'd like to hear more, if you can provide it, on the role of the accreditor and the expectations of the accreditor under the provisions here.
Any immediate reaction from Ed on this?
Just reaffirming those lines of communication with throughout the whole BD process, that we would be in touch, close contact with the close school issues, and with the states as well, or state regulators as well.
If I could follow up with a question, it does indicate that there could be no requirement for students to engage in internal dispute processes at the institution before contacting the accrediting agency. So I'm just trying to get clarification around process and expectation for the institution, for students, and the accreditor in the event that the student is having an issue that they're trying to move forward in various directions.
So, I mean, I guess the expectation is always the same. It's something new, more than what we would expect of the accreditors, and that is to conduct its quality oversight over the institution and to ensure that, you know, the student is receiving quality education. If not, that the accrediting agency reflects that in its evaluation of the institution as appropriate. We want to be there for, you know, to ensure that we're enforcing our regulations and that the accreditor is enforcing its standards, all for the benefit of students and borrowers. I see your hand, seeing my hand.
Yeah, please, yeah, Heather, go ahead.
So I think that there's no question that we share that mutual interest. I guess I was getting at more procedurally. Students come to accreditors with either complaints or what we call third-party comments when an institution is undergoing evaluation. So I was trying to get at whether accreditors can require students to try to process those complaints through the internal process available at the institution, provided they are still current students, prior to contacting an accrediting agency for resolution, or is this prohibiting that kind of first attempt at resolution with the institution?
I don't think so, but I would think that should something like this come to the accreditor's attention, that it would follow through. I mean, it is clearly a quality issue, so I think both are true. I mean, if the borrower, if the student is unable to get recourse from the institution, I'm assuming that's why they're reaching out to the accreditor. And so I just wouldn't want to see a student be stuck in this loop where, you know, the institution, they're not getting what they need from the institution. The the accreditor's telling them to go to the institution. I think there's steps that we all can make as oversight entities just to kind of ensure that, you know, our I's are dotted and T's are crossed. So no, it would depend on the particular case, but the language itself is not restrictive.
So Heather, unless you have an immediate response, I see David and Jerry's hands are up. So not seeing any sign from you. David, go right ahead.
Yeah, I would say that, you know, there could be similar questions with the state agencies, right? All of which have their own complaint process for students and processes for hearing, evaluating the claims. I don't have the data, and so this is just based on anecdote that the majority do ask whether and to what extent the student has pursued appropriate internal institutional processes for resolution. I think that's important, but yet the agency, whether it be the state, the U.S. Department of Ed, or the accrediting agency, I share the concern about that, just a loop of bouncing students from one place to the other without the legitimate path to resolution, which could be within all three, right? The state systems are not dependent on a resolution or the decision of the U.S. Department of Ed. They're processed independent and weighed on the merits of the claim. And so that would need to continue. I did not see the language within this this proposed language, something that caused me to be concerned that would be changed. But Heather, if you did, I would definitely want to talk with you and make sure that the language is tight, both for accrediting agencies and state agencies. I think this is another example. At some point, we really do need to improve the communication among the three members of the triad. Like, how many times have we heard that in our careers? Maybe it's actually time to do something about it.
Thanks, David. And just really briefly, Jerry, before I give the floor over to you, I just want to recognize that Bethany is back at the table representing individuals with disabilities or groups representing. So with that, Jerry, please.
Okay, so maybe leading off from the communication piece. A student in a bad situation is not going to understand what an accreditor is. They're not going to have that knowledge. You know, these are, you know, folks, especially if they have no one helping them. These are people who had to raise their hand to ask to go to the bathroom 2 months before they're enrolling. They don't have that, you know, there is no way I would have known to go to an accreditor or what that even meant. So I just want to make sure that when we talk about communication, we talk in a way that we're reaching back to the population that we're talking about and working with, and ways to communicate with those populations.
Thanks, Jerry. So at this point, I'm not seeing any hands up. Jennifer, do you feel that the department has enough to move to a temperature check for tentative agreement on this regulatory text?
Yes, I think so. I think folks said that they were going to add things to the chat as they came.
Yeah. And then thank you everyone for doing that. This is really helpful. So if we are ready, if I can just see quick show of thumbs. So Josh, Justin, and Jessica, I'm seeing your thumbs down. Anything to add other than what's been noted? David, please.
I don't mean to jump. Let them go first, and then I'll back, you know.
I think. Sorry. Yeah, I think this is true throughout a lot of the discussions we've been having. Simply going back to 2016 is just not enough to meet the moment right now, and isn't enough to fulfill the commitments of the president and the secretary. And so, until the kind of additional issues that we've discussed are resolved, I'm not comfortable signing on.
Thanks, Josh. We'll go Justin, Jessica, and then David.
Thanks, Brady. I think this is along the lines of what Josh was saying, but if this wasn't brought up, and I feel like you did hit on the definition of borrower defense, we really feel like that needs to be addressed here. There's a court decision, 11th Circuit Court of Appeals, that specifically refers to this as a, quote, poorly written federal regulation with regard to this definition here. So, I mean, I think we need to take a look at that and then a whole host of the other things that have already been raised. Thank you.
Thanks, Justin. Jessica, anything to add?
Yeah, sure. Just that I think you know why I voted it down for the reasons that I stated. We are open to making changes to the rules, but we're not open to effectively banning the use of arbitration for schools.
Thanks, Jessica. And then David.
These temperature check votes are really difficult because there's so much nuance and going on. I mean, I did a sideways because it's such a great step in the right direction, but I just want to say that we're supportive of the amendments that have been, or the idea of around the amendments that have been offered by Josh and Justin, and really excited to see those be considered. And so, yeah, absolutely there. One point of clarification. And it's wonderful we have so many attorneys at the table. They can help me with this stuff. Does it effectively ban arbitration? Is arbitration banned by this, or is it an option to the students?
Go
ahead, Jennifer.
Thank you. I was just going to clarify that point for Jessica, because this provision is not banning the use of arbitration. It's prohibiting requiring students to go through arbitration and requiring disclosures if institutions use arbitration.
Yeah, thank you for making that clear. I understood it. I think I miscommunicated it, so I appreciate it.
All right. Thank you, everyone. I appreciate that dialogue. So I guess, Aaron and Jennifer, if you are ready, we are ready to move on to issue paper number 10, correct?
That's right, income-driven repayment. Brady, I just wanted to do a check-in with Raj. We had asked Raj to prepare some items. I just want to make sure that he's ready to go. I'll still provide the background, just want to make sure.
Yeah, so I can certainly present the two documents that I sent you this morning, just to provide some background on poverty guidelines and how we might think of that in IDR plans. My plan will then present more tomorrow with some other maybe numerical simulations and some other background, and again in November. I'm certainly ready to go now.
Just for the committee's benefit, two documents were just sent to your emails that Raj might reference during this discussion.
Thanks, Kayla. Whenever you're ready, Raj, you have the floor.
Okay, thanks. Let me just pull those documents up so that I can share them.
Actually, I think it might be better if I provide the background on the IDR and then give the mic over to Raj. Brady, I'm sorry.
No. Yeah, that works for me.
Does that work? Okay. Great. So just moving into our IDR discussion. Some background, as you know, borrowers increasingly rely on income-driven repayment plans to navigate their student loan repayments. These are plans in which a borrower's monthly payment is set based upon their income, and any remaining balances are forgiven after a certain number of years. We have several of these payment plans. Two versions of income-based repayment are spelled out in statute. Others, such as income contingent repayment, such as pay-as-you-earn and revised pay-as-you-earn, stem from authority as outlined under Section 455 of the HEA. Just to clarify, these plans are only available on direct loans held by borrowers. We believe that IDR is a crucial payment option, but we have identified some challenges with these plans that we'd like to discuss further with this committee. The first one, which we hope Raj can shed some light on tomorrow in his remarks tomorrow, is that most IDR plans offer payments equal to 10 to 15% of a borrower's discretionary income, which is defined as their income above 150% of poverty line based upon household size. While this formula results in lower payments for borrowers, we find that many lower income borrowers are still not able to afford those amounts. And Raj can speak to the poverty line based upon household size today. Another issue is that while IDR plans reduce monthly payments for borrowers who pay less than the rate of accumulating interest, they see their balances grow, and sometimes significantly, and that can be very discouraging for borrowers. Also, existing IDR plans offer forgiveness after 20 to 25 years. Again, this may benefit those with higher balances, but may be too long for those who have low loan amounts or have low incomes for long periods of time. So we're concerned about lower income borrowers and borrowers with lower balances. We want to reach those borrowers because we find that they often end up delinquent or default on their loans. This suggests that these plans are not doing enough for this category of borrowers. The various IDR plans have differing terms and differing benefits depending on your individual situation, further complicating how a borrower may choose among them. So based on all those concerns, the department is interested in creating a new IDR plan using the ICR authority that addresses those challenges I just described. We are interested in feedback from the committee on those issues and have crafted discussion questions toward that end. I know Raj has already begun some work on providing us with information on poverty guidelines and how they intersect with IDR plans. And we're going to advance this discussion further tomorrow. And just to help us with a discussion, I'll just read the first two questions out loud, and then I'll hand it over to Raj for discussion. Okay, give me 1 second. Okay, so question number 1 is, there have been proposals to lower the percentage of income that must be paid for undergraduate loans. Should the department reduce payments to 5% of discretionary income? If so, which types of borrowers should be eligible for payments set at 5%? Should the percent of income devoted to student loan payments rise as income increases? And then does exempting income up to 150% of the federal poverty level based upon family size protect enough income for borrowers, particularly low and middle income ones? If not, what is appropriate level to protect sufficient income? And at this point, I'll hand it over to Raj.
Thanks, Jennifer. Let me go ahead and share my screen. So this first one is going to be the Poverty Guidelines 2021 document that you should have received in your email. So thought it would be helpful to first just get an understanding of what poverty guidelines are and how they're used in some of our federal programs. They're currently used in the IDR programs in various ways. And it's common that eligibility in other federal programs also depend on individuals or households' income relative to the poverty guidelines. So these are from HHS, the U.S. Department of Health and Human Services. These are published every year. What I'm showing you here today are the poverty guidelines for what we call the 48 contiguous states and the District of Columbia. So Alaska and Hawaii are going to have their own separate guidelines, but this will give an illustrative example for most of the states in the country. Now, one thing I just want to make sure people know is the poverty guidelines are a little bit different than what we call poverty thresholds. I know this seems like it's parsing language somewhat, but poverty thresholds are what we use, and this is produced by the Census Bureau typically, to say, is somebody in what we consider poverty based on income, okay? The poverty guidelines are distributed by HHS, and these are used as benchmarks for eligibility, okay? And so sometimes you have to switch a little bit between these, because if we say something like, what is the share of a certain group that is in poverty, that's actually relative to the poverty threshold. Whereas if we say, is somebody eligible for a program, or in this case, if there are a certain amount of income that is protected, we're going to be using the poverty guidelines. They're slightly different. They're largely very close to each other in a lot of cases, but I do want to point that out just in case anybody has any confusion about that. And again, I'm happy to talk about that in more detail. So how we can think about the poverty guidelines, again, is often in federal programs, these are used for eligibility for that program. So some pretty popular ones are Medicaid, so the Supplemental Nutrition Assistance Program, or SNAP. And for those, effectively, if an individual or household has an income lower than a poverty guideline, in some of these it's 100% or 150%, then they would be eligible for that program. There's a Department of Education program called TRIO, for those of you familiar with it. Students can typically qualify for that if their income levels are less than 150% of the poverty line. But for IDR, it's a little bit different. So currently in the IBR plans, for example, we calculate what's called discretionary income using these poverty guidelines. And in this case, for the IBR plans, it's 150% of the poverty guideline. So let me just give a quick numerics example, and I'll spend a little more time tomorrow. I shouldn't have the time today to kind of write this all out in a slide, but I'll do this more numerically tomorrow with everybody. Let's say a borrower makes $25,000 a year, and they are just a single household. So that would be 150% of the poverty guideline for a single household member would be $19,320. Let me see if I can actually draw on this. I'm really going to get professory for you here. So this 19,320 would be the relevant poverty guideline for that borrower. That means that effectively that first $19,320 that individual makes would be what we would call protected from their discretionary income. So the discretionary income would be the income above and beyond that $19,320. So again, if somebody made $25,000 a year, we would subtract 19,320 from 25,000. If I did the math right, it's about $5,700. And so that would be the discretionary income of which borrowers would pay a portion of in these IDR plans. Now, one of the proposals might be changing, for example, the poverty guideline. So if it was changed to something like 200%, then the poverty guideline would be $25,760. In this case, for a borrower who made $25,000 a year, again, we would subtract that. Effectively, they wouldn't have discretionary income, right? It would actually be a negative number, but effectively, they wouldn't have discretionary income, okay? So I'll go into this again in more detail tomorrow, and I'll try to provide some numerical examples. But all else equal, one of the things to think about with pulling any of the levers on some of these things, whether it's poverty guidelines or the percent of income that is paid out in some of these plans, is that all else equal, and I know there's a lot of these things are a lot interconnected. If you have a higher income protection, so if a larger portion of the poverty guideline is covered, then you would expect that borrower to have a lower payment on a monthly basis, and also possibly a larger amount forgiven at the end of their term. Again, there's a lot of kind of other considerations, but all else equal, that's what we expect. Now, the trade-off often with this is that the longer number of repayment periods can mean that all else equal, that debtor can pay more in interest over the life of their loan, right? So this is a trade-off between how much somebody has to pay on a monthly basis versus how much they pay overall over the life of their loan. The other thing, which is a consideration, which I'm not sure if it is going to be discussed in these sessions, is the tax liability on a forgiven balance, right? And so on the one hand, forgiving a larger amount of loan might be a benefit to the debtor because that's the amount that they might not pay, right? But if there's a tax liability on that, by that I mean if they have to pay taxes in the year in which this outstanding balance is forgiven, then that would be higher, all else equal, if they have a higher balance at that time. So wanted to provide this background kind of leading into our discussion tomorrow about thinking about poverty guidelines. I think it's helpful often to think about this or to have a figure like this in front of me so I can kind of think about, just the dollar amounts relevant for this. These are updated annually, and what I've put here is both the annual amounts and then also the monthly amounts. It's effectively just the annual amounts divided by 12. Again, for different household sizes, in this case, 1 to 8. The schedules actually go out to larger household sizes. And you can also, there's also some scenarios with, 125% or 50% of the poverty guidelines, and that's available in the link that's in the notes to this document, and I can also put that in the chat if it would be helpful for folks. So that's poverty guidelines. Are there any questions about that before I move on? Can't see everybody with my shared screen, so.
There are some folks who've added thoughts to the chat, but I would welcome them to voice them, or if anyone has any new comments or questions, please feel free to chime in.
So Raj, you mentioned, and Chris answered this in part in the chat, you answered the liability question, the tax liability. I presume that it's tax liability for forgiven principal on a student loan, not necessarily forgiven interest. So if interest is forgiven and it's not been added to principal, is there current tax liability for that portion?
I'm going to allow one of the lawyers or legal folks on the phone to answer that if they are able to.
So Persis is right. I believe it's through 2025, and that was provided through, Brian, correct me if I'm wrong, through the Appropriations Act.
Yes, through the Appropriations Act passed in December. Discharge amounts are not taxable until I think it's 2025.
Thank you.
See Christina and Dixie's hand up. Christina.
Well, I'm an alternate, so I don't want to speak without permission, but I did want to explain my comment. I'm looking at this from two ways. So there's the flat percentage rate that you're applying to all borrowers, which has the problem of being essentially regressive on lower income earners, because there's, as we know in financial aid, there's a protected income, or there's a presumed amount you need, to meet your basic expenses. And then people with higher income, of course, have more discretionary income. So the impact of a flat percentage rate is less, even though dollar amount, the low income family is paying less. It's still a greater proportion of their discretionary income because they simply don't have it. So that's how I'm thinking about that. But then the fix, of course, that you're providing is to go to a tiered percentage rate, right? To bring down the percentage rate for the lower income. And while I support that in theory, I'm worried about the cliff it creates for those, and the disincentive to be a higher wage earner, for those that would cross over into the higher rate. And I don't know if that had been addressed in the chart or not. That's my contribution.
Thanks, Christina. Dixie.
Yeah, so I'm not sure if this is where I should talk about this or, mention it, but I was wondering if there would be consideration about like poverty levels, like regionally, because specifically in OC in Orange County, our poverty is very different. It looks very different than what it is federally. And to be poor in OC is to be like, right, it's extreme, right? So poverty in OC is not the same as it would be across the nation. And specifically to my lived experiences, the way that I live as a poor person, as a low income person, it may be very different to someone else. And so I would wonder if there would be special consideration regionally, at the very least, to what poverty levels are, because I know that other folks that are considered low income, my lifestyle and my low income looks very different because of the school that I attend in Orange County and the fact that I live in Orange County.
Thanks, Dixie, for that comment. Substantively, I'm not going to respond, but that's for kind of the committee to discuss. But what I can say is that in the next document I have, I do talk a little, I'll provide a little bit about regional variation in poverty as well. And in some federal programs in which poverty guidelines vary by state, but in others, it's a federal, and I will mention that as well.
Great, thanks. Persis, who I should announce, is also resuming her seat at the table on behalf of legal assistance organizations. All yours.
Thank you. This is somewhat of a procedural question. So I'm curious whether or not we are starting to engage in the conversation about what the regulations are, or are we engaging in conversation on questions for Raj? Because if we are talking about questions for Raj, I'd love to give Raj the floor. However, if we are engaging in conversation about the actual proposals that are at the table, I'd like to get the department to respond to whether or not this conversation will include the discussions that I raised about defaulted loans. Though I think that that is actually very relevant to Raj's discussion, since the majority of defaulted loan borrowers are living in poverty as well.
Jennifer, please.
Yeah, I agree with you, Persis. It's I think all these issues are overlapping, and I think from some of the discussion points that you raised on defaulted borrowers, I think they are pertinent to some of the discussion here. So to answer your first question, yes, we are getting into the IDR discussion broadly, while we are also asking more discrete questions regarding Raj's presentation, but to the extent that these are all overlapping issues to inform the IDR plan that we're putting forth. And you can see that this issue paper is written much more open-ended, and we're really, we really kind of felt like we needed more feedback from everyone before we engaged with it. But certainly the defaulted borrowers issue certainly falls into some of the things we'll be discussing under IDR, but there are, other proposals that we are putting forth with regard to default that are not on the table here for this particular negotiated rulemaking, where some of the issues that you raised might be a better fit.
Thanks, Jennifer. Yeah, so I think, Raj, if you want to, if anyone wants to ask specific questions to Raj, we can just finish up that, and then if not, we can return to the questions that Ed has raised. So with that, Persis.
Sorry, not to belabor the point, but I think it would be helpful as we're asking questions of our experts for us to understand what we are asking about. And so if we're going to be discussing issues of default at this negotiation table, I think it would be helpful to understand that in advance so that we can utilize our experts as best as we are able.
Point well taken. I mean, I think that discussion is relevant to IDR to the extent that we can provide better protections for lower income borrowers that we find in default under the current plans. What can we propose that's better for them in particular?
Well, under the current plans, defaulted borrowers are not eligible for income-driven repayment. So my question is whether or not we are going to add a discrete issue about for adding protections for defaulted borrowers to this negotiation.
So we're not adding any issues at this time to the extent that the discussion is relevant, pertinent to this discussion and keeping borrowers from defaulting. We're open to hearing those ideas.
So then procedurally, we had deferred the conversation about the proposals that I had raised on Monday until this conversation. And I would like to revisit that conversation about whether or not we can add topics to the table. And I believe that that is something that can be subject to a vote.
So I'm deferring to you, Jennifer, how you'd like to address this. If you want Raj to continue, or you want to move to return to versus outstanding issue versus the issue paper that you've introduced.
Yeah, I'll be consistent with what we said from the beginning and the outset, which is a lot of the discussion on default might be taken better outside of this negotiated rulemaking. There's some, obviously these issues are overlapping, so to the extent that it's relevant to this discussion on IDR, we're happy to talk about it. At this point, we wouldn't support adding any more issues on the table, given that we have still a couple more that we need to get through by the end of this first session. But your point is well taken, and I'll defer to Brady in terms of process, and if Persis would like to bring this to add more issues to the table.
Well, I would just, so Persis, feel free to jump in, but I would only say that under the protocols, these are open for a consensus check to add new topics of negotiation to the rulemaking session.
So I would just like to ask that we then do add this topic to the negotiations. You know, as I stated in the proposals that were circulated, you know, there are currently roughly 9 million borrowers in default, and they are experiencing a lot right now, fortunately, because of the payment suspension. Most of them are not experiencing involuntary collection, but they are subject to having their wages taken. They're subject to having their Social Security taken. They're subject to having their entire tax refunds taken, which includes the earned income tax credit and the child tax credit. And while the department is currently working towards restarting payments on February 1st, that is the beginning of tax season, which means that when the switch gets flipped back on, millions of borrowers are going to have their tax refunds, which include the child tax credit, which has lifted millions of children out of poverty, seized immediately. And that is a subject that I think that this rulemaking committee needs to take up. We need to have protections for those borrowers. And I think, you know, it can't be deferred for another day. I think they need to have protections now. I hear from borrowers all the time telling me about how the seizure of their tax refund is threatening their ability to go to work, how it's threatening their ability to keep housing. Hundreds of folks have told me about how they now live in shelter because they fell behind on their rent. They were counting on their tax refund and they could not pay their landlord back, and so they were evicted. This is an immediate issue that's going to come up for borrowers before February 1st, and so I believe that it needs to be an issue at this rulemaking. And I would like to get a consensus vote.
I was going to say, Jennifer, unless you have an immediate response, I would ask for a consensus check on this, but I see your hand is up.
Yeah, just if Persis, if you could articulate those proposals again for the pleasure of the committee, and real quick, all those conversations, everything surrounding debt collection, the department has already started that discussion. It's just that our debt collection practices are authorized elsewhere in the HEA. It's not authorized under Title IV, which is what this negotiated rulemaking is about, just to put that out there. But we will be discussing that at some point.
So just
certainly underway at the department.
I appreciate that, and we certainly welcome any insights into what the department is planning for defaulted borrowers to protect them from these involuntary seizures that are going to start on February 1st. The proposals that I had submitted and sent around were, the first was to create an additional pathway out of default for borrowers. Currently, there are two methods that borrowers are able to, well, there's four, where payment in full and complete settlement is being two of them, which is not available to the vast majority of my clients, but rehabilitation and consolidation being the other ways that borrowers getting out of default. Those are very limited. The CFPB has data that shows that a lot of borrowers redefault after those programs. And so therefore I suggest that we create a new pathway. I sent around the statutory language, which I believe gives the department the legal authority under the Higher Education Act to create a new pathway, which would be more flexible, which would get borrowers into income during repayment faster, and would have less restrictions on borrowers' ability should they redefault again. So that was the first proposal. The second proposal was to have the department end its use of the acceleration clause so that borrowers could automatically be placed into an income during repayment when they do default, so that any involuntary collection that occurs through the Debt Collection Improvement Act, as you alluded to, would be limited to the income during repayment amount. Therefore, meaning that any borrower who was subject to involuntary collection would not be done so punitively, but only to the amount that they would have been expected to pay under an income-driven payment amount.
All right, and David, I see your email about this. I'm just gonna, yeah, please.
I really appreciate Persis putting this together, and it's very well done. I think I agree with the proposals, and I guess my only question before voting to add it to the agenda, which I think I'm inclined to do, is if the department is prepared now or later today or tomorrow to articulate what it is they are planning to do about these issues. So if they're going to take care of them, that's great. But if they're not, and we need to compel it through the regulatory process, giving the deadline, the timeline that we're facing and the cliff, I think the more we can do to better prepare students and deal with the repercussions of the student debt collection that's about to start, the better. So I'm seriously concerned about that issue. Thank you, Persis, for pushing this. I would like to hear what the department's doing and planning to do. If they're taking care of this, great. But if not, then that's another matter.
Oh yeah, Brian, please.
Yeah, I would just note that won't be final until fall of next year. So to the extent you want to propose ways for the department to ease the transition of borrowers back into repayment beginning in January of 2022, those need to be addressed more appropriately to the department's leadership in a different form. You know, we're looking here, we're developing regulations that will, as I said, be published next fall and will go into effect primarily in July of 2023. The changes Persis has suggested, you know, may be considered forward in the future. As the department has stated, we're not sure that we have time or bandwidth to take it up in this process because we have a big agenda now. But I just want to, you know, if your focus is on what happens in January 2022, this isn't the place that those changes are going to be made.
Yeah, Persis.
So I appreciate that that there is a delay in the time frame in which the rules that we negotiate now will take effect. I think that's all the more reason and why we should do it now, though. There are hopefully things that the administration can do and will let us know that they are doing in the interim to protect borrowers from this cliff that we are facing on February 1st. However, given the fact that default is always a problem and it has been a problem before the COVID crisis, I think that's all the more reason why we need to do it as soon as possible. And this is the rulemaking. We have the opportunity to write rules that could make meaningful protections for millions of borrowers. These are our most vulnerable borrowers, and they need to have the protections as soon as possible. And I think that means doing it during this rulemaking. I think if we don't have time during the current schedule, we could also create a working group that could meet outside of the scheduled times and could make a presentation to the main session as well, which would be a way that we could both accommodate all of the issues that we have at hand and also work on this vitally important issue so that we can get relief for these borrowers as soon as humanly possible.
Brian or Jennifer, any additional response from the department?
I just want to make clear that, you know, I just don't think that this is the right place for it. And I just want to affirm the department's commitment to all borrowers. If you know, we extended the CARES benefits to expressly to defaulted FFEL borrowers early in the year. So we are continuing with that commitment, and all I can say is those discussions are well underway at the department. This particular negotiated rulemaking table is not the right place for those issues right now.
Yeah, Dixie.
So Jennifer, then I asked a question, and Brian too. So then what would be the right time to raise these concerns, these, issues that Persis raised up? Definitely not after February 1st, right? I would hope not. But that's my question. When would be the right time then?
If I may, Brady, I'm seeing David reiterate in the chat what he mentioned in his prior comment, right? Which is giving an opportunity to the department to speak to what Persis has raised and proposed, and it has been circulated to all of you. I'm wondering if we hit a brief pause button, even on the consensus check here, and allow everyone to give this a little bit further consideration, and perhaps if there is any additional response from the department, that the department can come back with, and then we will in fact take a consensus check. Are you amenable to that? Everyone, maybe I'm seeing a couple of thumbs up, a couple of nods, so I'm gonna run with that, folks. Let's hit the pause button here. Why don't we take a quick break, come back. If there's anything additional we need to hear from Raj, we can do that. And then let's move into some of the questions that the department is hoping to get your feedback and insights on in that issue paper. I have 2:18, so let's come back at 2:28, a good 10 minutes. That work? Okay, we'll see you then. Thank you.
Thank you, everyone. Welcome back. We have about an hour remaining before public comment. We do have a full public comment period today. So in the interest of utilizing our next hour wisely, do we want to pick back up with offering questions and comments to some of the questions that Ed has lined out, given issue paper number 10? If that's okay with you, Jennifer, I'd ask Aaron just to briefly reshare it to guide our discussion.
Did you want me to finish up just the discussion?
Oh, shoot, Raj, I apologize. Yeah, if you want to reshare your screen and finish up that second half of your presentation.
I'll go very quick.
Okay.
So the second document I provided here are just some other background documents just to get us thinking a little bit more about poverty. Let me just say that tomorrow I'll present some more about IDR plans specifically, do some specific numerical simulations and examples. And certainly if there are specific things that folks on this committee want, please let me know, especially as we go into the out of this session, you know, having 3 weeks to work on things before November will certainly give me time to do some analysis. So please go ahead and let me know if there are things that come up with that. So one thing I wanted to mention with this, and I think this came up in a chat question as well, is it's important to note that everything I'm presenting here today is based on income. Income is only one measure of how we might think of social welfare. Nothing I'm presenting here is related to other things we might think of, such as wealth. There's also been a number of research efforts to measure things like material insufficiency or other conceptions of poverty. What I can say is that one of the advantages of income is that it's more easily recorded in a lot of federal data systems or in data systems more generally, right? So there are reasons to think that other measures of poverty, wealth, material insufficiency are incredibly important, maybe even more important than income when we think about poverty or social welfare. But there are data challenges in trying to record some of this. So I did want to point that out, and happy to talk more about that in future discussion. The first figure I show here is really to actually was something that Dixie astutely picked up on in the earlier discussion, and that is that there is geographic variation in how we might think of poverty. So this is a map from U.S. Department of Education, which just shows the percentage of children under the age of 18 living in poverty based on their household income. And so the darker blue are those that are a higher percentage living in poverty than the national average, and the lighter blues are those a lower percentage. So as you can see, there's clearly variation across the country. What is not shown here, again, to Dixie's credit, pointing this out, is that there's clearly a lot of within state variation within this as well. This could be based on regional factors, labor markets, other things. Also, there's variation if we look across general geographic categories like urban, suburban, rural areas as well. Now, as I mentioned before, some federal programs do have different poverty thresholds, poverty guidelines by state. Medicaid's a prominent example of this. What I would say with that is that in Medicaid, for example, that's a federal state partnership program in which the federal government and the state government really work together to implement that program. Federal student loans, at least thus far, have not operated in that fashion. And so often when we see different guidelines by state, that's often where the state has a prominent role, either administering or dealing with that program as well. The second and third figures here, just wanted to also point out that poverty rates vary by race and ethnicity as well. This is a measure or a figure that comes from the Census Bureau, and this looks over time at the percent of individuals who identify as certain races, ethnicities. In this case, Black, Asian, and Hispanic are listed, and non-Hispanic white, how poverty rates have changed over time. There has been some convergence over time, but as you can see from this graph, there's clearly still some large disparities among the different groups. Figure 3 here is in a similar spirit, but a slightly different group. Again, these are children under age 18, a figure produced by the Department of Education. A handful more races and ethnicities included in this graph, but as you can see, certainly here, we still see some disparities in poverty rates by race and ethnicity. Finally, this last figure I have here, this is a figure that came from a Pew Research Center report. And so there is a differential income distribution at different types of schools as well. So this is a little bit older data. It's from 2016. It's actually still the most current data that we can get for this question specifically. And I'll also point out here that this is just dependent undergraduates in this. And so obviously we know independents are also critically important in a lot of these discussions as well. But for dependent undergraduates, if we focus on just 2016, I think the highlight here is that we can take away is that those bottom two categories there, which are private for-profit institutions and public two-year institutions, have a larger share of students either living below the poverty line or near the poverty line, certainly relative to the other two categories of institutions in here, public 4 years and private nonprofits as well. And so just wanted to also provide some background. I think a lot of folks know this, that the income distribution of students is not even across institution type. The other thing I'll say with all of this is there's clearly a lot of intersectionality across institution type, race, ethnicity, gender, where folks live, other things as well. And so again, if there are specific requests or questions, I'm happy to dig as much as we can on some of these data. Again, in some cases, the data is just limited. So that's all I had to present today. I saw there's some questions in the chat that I'll respond to now. If there's anything for me, I'm happy to stay on, but otherwise I can bow out and let the committee get back to their deliberations.
Hey, Raj, I'm not sure if any of the questions in chat are immediately addressable, but I do see Bethany's hand.
I just wanted to say the question that I put in the chat out loud, because I think one of the challenges that we run into when we're talking about poverty level is the churn that happens because people's income varies over the course of the year. And so I don't know if it exists. I know churn is a huge problem between Medicaid and the ACA exchange plans. And if there was any information on churn and like if there's a way to minimize that with different income phases, I think that would be helpful. But I also totally understand if that's not available because it's, yeah.
Yeah, so what I can say is there's certainly research evidence based on more limited samples, not systematic data sometimes, that certainly demonstrates what you're saying. Whatever threshold that we put forth to measure poverty, a lot of people's circumstances will fluctuate in and out of that over time. And so, sometimes we think of this concept in research as persistent poverty. And so there are certainly a lot of people also living under those conditions as well. But I think you rightfully point out that in a lot of programs, whether for federal student loans or other programs, the big issue is that people qualify at certain times in their life and they don't at other times. And that's certainly something we see. I can try to put together kind of the best we know on that and send it out. But the short answer is that what you're describing is certainly happening.
Versus.
Thank you. And thank you for this. And I appreciate your comments earlier about how this doesn't take into consideration factors such as wealth, which is obviously very important and also has huge implications when we think about the disparity between different races and other different groups of borrowers. I'm curious if you also have research on differences in expenses, which is also not taken into consideration with this formula, and certainly amongst many immigrant communities that I know personally, but I'm sure there's other research out there that shows that different communities also have different expenses with regard to whether or not they're caring for extended family, whether or not they have higher expenses because of childcare, other sorts of things, and I'm wondering if that's some of the research that you could provide for us as well as we consider this formula and what's appropriate. I also will, just to flag for you, have some data requests with regard to how we break down how the income during payment plans have worked. I won't put them in the chat because it's currently 5 pages long, but I will email that around to you all.
Yeah, I'll just respond to that and say, I agree with you completely on these different measures, and I think it's incredibly important. It is difficult to measure, and I know researchers say this all the time in other measures, but certainly happy to try to pull together what we can. And what I would say is for a 5-page data request, some of that's probably going to be directed to the department. And the things that I can find on my own, just ask that I don't try to get it done by tomorrow, but I will do my best to get it as much as I can for the November session.
Yeah, Michaela.
Sorry, it wasn't turned off mute for me. If you are doing any type of like demographical breakdown, could you also include students who have dependents, such as like student parents? Because there's been other data by IWPR that's shown that student parents are some of the highest loan borrowers. And I know we talked about children who live in poverty, and I think kind of connecting those dots would be really helpful.
Yes, so what I tried to rely on today, again, was kind of anticipating some of the requests, was kind of figures and tables that are already published in other reports. There are some data sets we can dive into that might be able to pull out specific things that might not be available in some of these other things, like parents. I mean, independent students is actually a research interest of mine as well, in that, and they're not often given the same attention in some of the reporting as dependent students. So.
Right, not seeing any new hands. I just want to thank you again, Raj, for spending so much time with the committee. And with the remaining time, and again, we do want to ask folks who have signed up and received confirmation for public comment to join the meeting a little bit early, just so we can make sure everything's going well on your end, so we can bring you into the room at your slotted time. But Ed, do you want to, Aaron, could you reshare the issue paper number 10, just so we can use it to guide our discussion for the next little while? Oh yeah, Marjorie, sorry, that's your hand. Oh, you're
so
good?
this
Okay.
is actually about the issue paper, not any questions for Raj. So are we ready?
Great. I think we can jump right into the only thing that I'll say is that there is a number of questions on this issue paper, and people probably have questions and comments throughout the document. But just maybe for sake of ease of the transcript, if folks want to maybe speak to only the first 2 questions initially, and we can obviously return to you once folks have questions related to 3 through the rest of the document. So with that, Marjorie, floor is all yours.
Yeah, so the first question that I have about this document is the rationale behind only lowering the percentage of income for undergraduate borrowers. There's a significant number of students who, in fact, only borrow for graduate school education, and that's a substantial burden as well. And well, I understand perhaps the earning potential might be the rationale. It really doesn't make sense to me why we would distinguish between undergraduate and graduate borrowers. So I think that is something that's really concerning and would sort of make an unnecessary distinction between when you got your loans, because it doesn't change what you're paying and how much you have to pay back. So on that point, I would strongly, I guess, suggest that we don't do that. And if we're considering lowering the income threshold, if there are borrowers who are signing up for this payment plan, whether they were undergraduate or graduate borrowers, the issue is that they don't have the resources to make those payments, not when they got the loan. So I think that wouldn't make sense to make that distinction.
Great, and again, throughout this, anything, feel free to add it to the chat. We really want to encourage a robust transcript for this process. So with that, Persis, please.
Thank you. I second Marjorie's comments about separating between undergraduate and graduate. I think especially when you look at the data with regards to racial disparities, we know that students of color are more likely to feel the need to get a graduate degree in order to compete with their white peers. And so making sure that whatever affordable repayment plan we have is available for graduate students is incredibly important. I think based upon my experience with clients, the stories that we hear from across the country and the data that Raj just shared, I mean, I think we know that 150% of the federal poverty level is insufficient to protect for a lot of folks. IDR is simply not affordable at this moment, and I think that raising the discretionary income threshold is the most important way to ensure that low income and middle income borrowers have the most amount protected so that they can afford the basic necessities for their families.
Thanks, Persis. Bethany.
So I'm going to talk about both 1 and 2, echoing Persis and Marjorie's comments. I think there's a balance to be struck here between, as you probably guessed from my comment about churn, and about people moving between income areas. I think there's a balance to be struck between setting the baseline low enough that we catch a bunch of people and then also not necessarily moving. This is with regards to the department's question specifically about should the percent of income rise as income increases. And that's where I'm not opposed to that, but I think implementation wise, that is going to be challenging for the department and for students. And so that's just something we should keep in mind, and setting the kind of baseline as high as we can, I think will address a lot of that. On 2, I mean, we just saw a collection of data on this, and I think Dixie's point about geographic diversity is really important here. I would want to increase it from 150% of the federal poverty line. I think that's important. And I also wonder if that's actually a more appropriate way to have that phased out piece, rather than to kind of address, I think what was brought up earlier, and I apologize, I don't remember who brought this up, about folks kind of hitting a cliff. We run into that with a lot of different public benefits programs where people are getting a lot of help and then there's a cliff and then they're not. And so I think anything we can do to reduce that cliff will be important. That's it for the first 2.
Thanks, Bethany. Michaela.
Yeah, for that second one, I think that 150% of the federal poverty line just really isn't like enough. Like, I don't think that that's high enough. I think that for 2 people, that was a 2-person household is like 26,000, I think. And I think, you know, either you have 2 adults, but like for me, like I'm a single mom. That means that like only up to $26,000, and I'm sure that there's anywhere really that $26,000 would be enough for a single parent to live off of, truthfully. And so I think really being mindful of that implication is important.
Thanks, Michaela. So I'm not seeing any hands. Oh, Jennifer, please, yeah.
Just real quickly, I should have read all 3 questions. They tend to go together, and I think you've already some of the comments speak to number 3. So just how should the department think about the interaction between changes in the share of income devoted to payments and changes in the amount of income protected in terms of insurance plans that are affordable for low and middle income borrowers? So these 3 generally go together.
Yeah, Michaela.
I'm taking that as like an interpretation of a recommendation. I would say go to that 250%. That would increase a 2-parent household to $43,000 that was protected. I don't think that that's a huge ask. I think that, you know, the more that, especially because right now I live in Southern California, right? Rent itself is going to be at least $1,400 for like a 1-bedroom, right? So like that right there would be half of my income. And other programs, I think, are starting to look at that 250% income, particularly housing assistance, which will allow some assistance up to, I think, actually, in fact, a higher level. And I think looking at where those other programs are viewing their points is important. But I do believe that in California and in many places, $43,000 a year as a single parent would still qualify you for public benefits. And at that point, I think that you should be protected.
Thanks, Michaela. So keeping in mind, just everyone, we're now looking at 3rd question, so feel free to ask point of questions as it relates to question number 3, as well as 1 and 2 if you didn't get a chance to ask those earlier. I see Persis.
So I would actually encourage to say that we could even go above 250%, especially if we're not going to be looking at measures that look at location or expenses or things of that nature. I think we need to recognize that folks do have a lot of different life expenses and wealth as well. And so I think that going actually above the 250 would account for that if we are not going to do something that would take into consideration expenses. I have 2 children, so I know how expensive, childcare is, for example. We have folks that come to us who may technically be above 200% or 250 of poverty, but their children have extraordinary medical expenses. So I think that actually going higher is a reasonable thing to do. 400% is, I believe, Medicare is where uses that as the threshold. And so I think that there are other examples of other federal programs that have gone higher than 250. And I think especially given the variations in borrowers' location, their expenses, I think that that would be a reasonable thing to do. I would also, I would resist the urge to tier down. I think, sorry for that, that when we kind of lower the amount as income increases, I think that was complicated implementation wise. And so we want to keep the program simple. I think if we could see the math out, I don't think that that causes a cliff effect. I think protecting, whatever amount for as many folks, the people with higher incomes will pay the same percentage over that amount. But I don't know that that would necessarily create a cliff. And maybe if we could see some mathing out of what the different payment amounts would be, might be helpful for this conversation. So thank you.
Thanks, Persis. Marjorie.
So I just absolutely want to echo everything that Michaela and Persis shared, and maybe another way to think about it. So when I think about, the form for even applying, it's simple, which is great. But I and others that I've talked to about this issue often feel like we don't get an opportunity to provide enough information. And so, parent as well, a single parent. And so my being able to put, well, it's me and my kids, and this is what I make a month, doesn't account for any other expenses, including, childcare and all the other things that come out. And so maybe procedurally, it's taking a look at the application. And again, I don't want to make it more complicated, but maybe as an optional or sort of other ways of thinking about how individuals can demonstrate, their need. Because I get that letter and amount back and I'm like, that's not going to help. So that's, I guess, maybe another consideration in addition to thinking about raising the, what we're looking at as the threshold or the guideline for, families who are enrolled in this program.
Thanks, Marjorie. Bobby.
We may also want to consider and kind of echo on what everybody else is saying, that this marriage penalty that's out there, where you have 2 single income individuals holding off getting life started and getting married, just for the simple fact that once they do, then an income doubles. And if you have 2 lower income individuals, that could mean a significant impact on the one that's on an income repayment plans. So just want to consider that.
Thanks, Bobby. Joe.
Hi, thanks. Question here on a theme that we've talked about on other topic areas regarding automation. People have talked about certain expenses that people have that may play on their ability to make a certain level of student loan payment. And one of those is childcare. Certainly the IRS captures a lot of data on, how many kids a person has, and they give various tax credits on that. I would question whether the department could look at using some of that data, given that I think tax forms are used to determine income levels now. So automation has the benefit of simplicity, and there may be other information that could be considered that would materially play into a person's ability to repay, as the committee has mentioned here, in particular, childcare.
Thanks, Joe. I'm seeing Bethany's hand, but at the conclusion of your comment period, Bethany, do we want to move on to the next set of questions? Seeing some nods. Jennifer.
Yeah, I think that makes sense unless anybody has, if there are any further comment regarding lowering the percentage of income that must be paid, please chime in. Otherwise, we can move on after Bethany.
I wanted to actually respond to Joe's point because I think that's very possible that the IRS does have that information. But one important thing that, especially during the pandemic, we have learned is that the lowest income families often are non-filer families. Below a certain baseline of income, you don't actually have to file your taxes. And so those folks are not in that database. And I wouldn't want to lose those families, especially those families in many ways. So totally agree that that could definitely be used, but I just we need to keep in the back of our heads that there are folks excluded from the IRS data set who kind of by definition are the lowest income folks we want to be targeting.
Stephanie, and I think closing us out is going to be Jennifer, who's stepping in on behalf of student loan borrowers. So welcome, Jennifer, and the floor is yours.
Hi, thank you. I also wanted to mention what Bobby said. I think one thing the trajectory of this is that we forget about non-traditional students. So we think like 18-year-olds going into college, but there's other students, especially students of color, who later in life go back into education, and they also are affected by this because by that time they already have a family, they already have children. So I just kind of wanted to add to Bobby's statement. Thank you.
Thank you. And then Aaron, if you want to scroll down a little bit, Jennifer, do you want to just restate the next set of questions you think are best to consider as a group for the committee?
Sure. Let's see. Question number 4 is regarding existing IDR plans, and they either use the same time to forgiveness or vary the time based upon whether a borrower has any graduate school loans. Should the department consider other bases for variations in time to forgiveness, such as whether a borrower is consistently low income or whether the borrower has lower loan balances or any other factors? I can read 5 too. 5 is a different issue, but that way just to kind of get people thinking. A lot of borrowers raise concerns about how interest accumulation results in them owing more after years in repayment. And that can be very disheartening for borrowers. How should the department address this? And should that approach vary based upon factors such as borrower income?
Thanks, Jennifer. I see Daniel's hand first, please.
Thank you. I have thoughts on both of these issues. So first of all, the department states in its prefix or introduction to these issues that that many low-income or low-balance borrowers still end up delinquent in default on their loans. And I'm really concerned about low-balance borrowers. I think that there needs to be a shorter time frame to forgiveness for low-balance borrowers, especially those that are some college or no degree. Those are the students who I'm very concerned about in this process. They experience the debt without the benefit of the college education in terms of income. I'd also like to explore on number 5, and this is why this ties in for me, the possibility of either zero interest rate during a period of income-based repayment where there's lowest income, or the possibility of forgiving interest. The principle of needs analysis is that you look at the income the student has or family has to make payment for college at that time, and I would echo the idea for repayment as well. By adding the interest or accumulating interest. In a sense, what we're saying is, we validate that you have difficulty paying based on your income right now, but we're going to hold you accountable for this in the future, and that seems to be penalizing. So I would strongly suggest the department look at either as a 0% interest rate during income-based repayment if possible, or if not, a forgiveness of any interest assessed that is unpaid. So we're not facing an accumulating loan balance for periods during which the payment is less than the minimum required. And as a final piece, I would also suggest that the department look at forgiveness as you go. So the other way to look at this is to forgive a portion of principal for each year that a student is actually in an income-based repayment period is another way of approaching this, rather than doing this as a lump sum at the end. Perhaps there's a mechanism by which, if the income-based repayment period requires 20 years, for example, a 20th of principal is forgiven each of the years that was unpaid during the time frame that the student is in repayment. So those are my 3 thoughts. I'm happy to type them in the chat, but wanted to lay them on the table.
Oh, you beat me to it, Daniel. Yes, please add them to the chat. I'm seeing Bethany. Go ahead.
So I'd like to echo everything Daniel said. I also would like to reiterate our comments earlier about differentiating between undergrad and graduate school loans. Completely agree that we should be prioritizing the lowest income borrowers. And in terms of the interest accumulation piece though, how does this interact with the interest accumulation proposal that we considered earlier in the week? I apologize, my brain is a little fried, but if someone could walk me through that quickly, I would appreciate it, because I'm just trying to cross-reference in my head and it's not coming through.
Can I offer a response? One of my concerns about interest capitalization is it deals with capitalizing and adding it to balance, but it doesn't remove it, so that the idea here is that our proposal before wouldn't add it to principal, but it would still stay out there as a pending obligation for the borrower to pay if indeed their income does resuscitate at some point or does go higher.
Does that satisfy your question, Bethany?
To some degree, yes.
All right, thank you. Persis.
Thank you. I have a lot of thoughts and I will try to get through them in my 3 minutes allotted. So, I mean, I think first in terms of thinking about the repayment period, this is another area where I think more data would be helpful. I'm particularly concerned about borrowers who for long periods of time have $0 payments, and why we're making them fill out paperwork for 20 years to continue to verify that they're persistently in poverty makes no sense to me, and I think it sets them up for failure and for defaults, frankly. So I think it would be really helpful to have data about, you know, how long folks, you know, like what is the population of folks who after 3 years, 5 years have $0 payments? What's the likelihood that they're ever going to actually repay their loans? Can we just forgive those? I have some concerns about modulating the forgiveness period based upon the balance. The data shows that Black borrowers in particular have to take on more debt, and therefore by structuring this by loan balance, you are disadvantaging those who have to take on more debt in order to attend school. And so I'm concerned about modulating in that way. I do agree that I think there needs to be some kind of way in which we capture folks faster, we give people progress. I would be open to suggestions about doing certain percentages by year. I like the idea of people making progress as they go, which I think kind of leads into the next part about interest. I think we just have to get rid of negatively amortizing loans. It's a real deterrent for folks to get into IDR and persist in IDR when they see their loan balances continue to grow. I think that and for most folks, or for a lot of folks, I don't know, I don't have the data on this, but for the folks that I see, it means that they're not going to pay back their loans, and it dissuades them from staying in the program. We need to get rid of negative amortization. I don't know that I don't see this in the questions, but we considered in the public service loan forgiveness conversation what counts as a qualifying payment as well, and I like that to be part of the conversation. You know, deferments, forbearances, and as we raised then, periods in which borrowers should have been into an income during payment plan, but were not because of perhaps malfeasance or steering on the part of their servicer. And then the last point that I will raise is, because I don't know where else to raise it in here, but on the interest capitalization question, there's deferments, and this is where I wonder if we couldn't create deferment-like programs into the ICR statute, because then we could ensure that interest that does accrue does not get capitalized. So I'll turn it over there.
Thank you. And this is to everyone. If for whatever reason you run out of 3 minutes, you're more than welcome just to re-queue. We just want to get as many people commenting as possible. So Michaela, please.
I was considering yielding my time to Persis, especially, you know, the only thing that I could add is that, you know, I've been following student loans on Twitter because you know, it's a great way to see student voice. And there are like so many stories of folks being like, oh, cool, I've been paying for 5 years or 7 years, and I have not paid $1 towards my principal. And so I just really wanted to point that out, that like, I don't in this case have a solution, which is why my purposes just keep going. But I think it's just incredibly important to acknowledge that when you're enrolling folks in these programs, we do know that there's a lot of them that just are going to wait out that 20 years or not be able to have it forgiven because it goes into other collections. So.
Thanks, Michaela. Joe, and then Persis, and then we'll just do a quick sweep of the room, and then we might have time to move on to the next 2 questions. So Joe, please.
Yeah, hi. Lots to address here, but I'm going to focus on the point Persis raised about negatively amortizing interest and how it dissuades borrowers from entering the program. Part of my job is to review all the higher education complaints that come into the Illinois Attorney General's office. We had over 800 in 2019. A consistent theme in those complaints is rising student loan balances and frustration with that situation. That to the extent that the department is considering the structure of the IDR program, I think that you would see more uptake in IDR programs to the extent that negatively amortizing interest was removed. There's a really interesting paper from 2018 that I will drop into the chat that has a University of Maryland study where they look at how the department currently talks about IDR, which emphasizes sort of a disclosure or a warning on the fact that your interest is going to increase, versus a separate message that they crafted around the insurance-like aspects of IDR. In other words, that if your income drops or you experience a loss of employment, your payment will drop. And they saw a material difference in student uptake with those 2 messages. So I see negatively amortizing interest as something that consumers don't understand. You don't see it in other consumer financial products. And it adds to confusion and frustration with the income-driven repayment program. I think that removing it would be a benefit to the program and to borrowers.
Thanks, Joe. I'm seeing Persis, and then I'm seeing Suzanne stepping in on behalf of the state regulators. So Persis, the floor is yours.
Thank you. So not to be a broken record for throughout these different topics, but I want to also raise that anything that we do needs to be retroactive. We also need to take into consideration failed borrowers. So I've had a number of messages from failed borrowers or borrowers who had failed loans and then consolidated into the direct loan program who have been in repayment for decades. And we need, whatever we do and whatever guidelines we come up with how we do cancellation, we need to somehow take into consideration the decades that people have been in repayment. We need to apply our rules retroactively so that borrowers are not in the position where they've been in a forbearance for the last 20 years, but now they come into this plan and they have another decade or 2 in order to continue paying their loans. So that's just it. My word of the day is retroactivity. Thank you.
Thanks, Persis. And Suzanne.
Yeah, +1 to Persis. Also, I appreciate Joe reminding, I think I may have said this as well, that it's very unusual to see interest accrual and capitalization in the consumer finance context. This is really an outlier here and a huge problem. I will also note that, we hear very frequently that the interest accumulation and capitalization event is a shock to people when they first experience it. It is not what consumer expectations expectation would be, student borrower expectation would be. It's kind of hard to get your mind around also because you don't necessarily know what your income is going to be year over year and what your debt to income ratio will be as a result. I know we've already talked about the department's consideration of removing interest capitalization. I want to reiterate our strong support for that. That would be more protective of student borrowers. And in addition, I want to make a quick tie to IDR and PSLF, right? Because I hear all the time, and actually I even checked in with Berkeley's financial aid office the other day to ask them, talk about the rulemaking, and they reiterated back, there are a lot of students who are skittish about betting on a public service career because they're worried that IDR is going to make their loans inflate, and they may not get PSLF at the end of it. There's a lot of concern. And so I hate to think that the way that these programs are structured could have a chilling effect on folks who actually do want to go into public service, which we've been talking about today, whereas many of those jobs are less lucrative than just a pure private sector job. So I think we should also be thinking about the interplay between the IDR plans and PSLF throughout this process to remember the kinds of students and student borrowers who are going to be impacted by both of those programs at the same time. Thank you.
Thanks, Suzanne. I'm going to give the final word for Jerry for questions 4 and 5.
I just want to say thank you to Susan. That's exactly what so many people have problems with. Thank you for articulating it so well. And if I could give her a +1 million, I would, because she hit it right on the head.
Yeah, the inflation rate for the pluses in chat is really out of control. And I do want to acknowledge that Dr. McTeer has taken a seat at the table, so welcome. So with that, Jennifer, I'm going to turn it over to you to reintroduce our next set of questions.
Great, thank you, Brady. Let's see, this is kind of been borne out by information that Raj has shared with us, and I think some of you have already spoken to this, but could build this out further. Question number 6, data show that underserved populations and communities of color face higher rates of student loan struggles than others. What design factors and changes can better support equitable access and success in repayment? That's question number 6, as we've been taking 2 at a time. I'm going to move on to 7 as well. Observers note that existing IDR plans may not be optimally designed to reduce delinquency and default. Borrowers at the highest risk of delinquency and default are typically non-completers who owe low balances, yet who do not enroll in existing IDR plans at a high rate. What design factors and changes can better support borrowers at high risk of delinquency and default, or otherwise encourage enrollment in IDR plans that match their financial circumstances and loan balances? Again, we're concerned about these borrowers that have low balances and low income. And I think David, we touched upon all these issues, but if we could build out that discussion a little bit further. Thank you.
Thanks, Jennifer. And just as we're about a little over 15 minutes from public comment, I'm going to ask everyone, again, if you've been assigned a slot to speak, please start joining this meeting so we can just make sure everything's set and ready to go right at 3:30. So with that, Persis, I see your hand.
Thank you. Yeah, so I think I've mentioned this before, but I think it always bears repeating that students of color have to take on higher loan balances. And so as we are thinking about equity and how we structure this program, I think while there are a lot of low balance borrowers who are in default, and that's an incredibly important thing to acknowledge, that disproportionately borrowers of color have higher loan balances. And so I would like to resist any urge to kind of segment by loan balance. I think we also should take into consideration, there's actually a recent journal article that came out showing that student loan borrowers of color experience higher rates of servicing errors and abuses. And so we know that there are access problems with accessing income during payment, and those are borne out by student loan borrowers of color primarily. So we need, as we are crafting, to take into consideration what happens to a borrower when they are steered. And then finally, for this round, the options for borrowers in default. Borrowers of color default at twice the rate of their white peers. And so having options for borrowers in default is critically important. the current regulations unnecessarily restrict the access to income generating payment to borrowers in default. My reading of the statute does not prohibit defaulted borrowers from accessing income generating payment. They should be allowed into the payment plan. They should have their time counting towards cancellation, especially any involuntary payments that are above the income generating payment amount should count towards cancellation. I think that would move us a lot closer, not quite there, to equity.
Thanks, Persis. And I'm seeing more hands, but really quick, I just want to recognize that Jennifer has joined the table on behalf of student loan borrowers. So I see Bethany, David, Michaela, and then Jennifer. So Bethany, the floor is yours.
I want to echo everything Persis just said. And I want to bring up something that's slightly more radical in the context of what I've been saying this whole time, which is, why are we not automating this? Like, I'm completely and utterly baffled by that. Like, if you have a student who is starting to go into default, like, the best thing to do is to automatically put them on an IDR plan. And that's going to prevent a lot of problems. If it's doable under the statute, I don't understand why Ed isn't doing it. It's baffling to me, I will just say. And I want to say that also disability rates are higher in communities of color. They're higher in low-income communities. That means you are by definition going to have more problems with paperwork and with the bureaucratic barriers that we've talked about repeatedly during this entire session. And so for me, automation in this is kind of the be all and end, that I don't think we should be doing everything else that Persis said as well. But I want to hit that point home because I think that there's a lot of problems here that could be addressed by that.
Thanks, Bethany. David.
Yeah, thank you, Persis, for those really good recommendations. And I would reference those that she provided in her comments just now, but also earlier suggestions around how we deal with interest, and Bethany's reference to automation. And I think what that gets to is that we will develop the best policy if we address those populations that are currently being poorest served, right? So if we keep in mind students of color, low income students, first generation students, and design the policy to better serve them, all students are going to be better served, right? And so I think that is absolutely where our focus should be: better information, automation, and readjusting the terms of the IDR so that we're not putting them in a worse position financially over the long term. Definitely putting folks that are facing default into IDR and doing it automatically if we can. All of that's going to benefit all students who are borrowers, but particularly it's going to benefit those that are facing the largest structural constraints. So I'll just leave it there.
Thanks, David. Michaela.
Yeah, just a consideration, because the question asked about like considerations for the design. I think that really thinking about not punishing people for being poor, that these programs shouldn't make you owe more just because you didn't have money. It just seems incredibly counterintuitive. And then also I want to build upon marginalized communities, low income, and students of color. Not that we have a lot of data on student parents, and I will continue to talk about them throughout these, particularly because I am one, but also representing independent students. Any student who is enrolled in college automatically becomes an independent student when they have a child. So a large portion of the folks that I'm speaking for are also parents. Data shows that about 2 out of 5 African-American women currently enrolled in an undergraduate program are also student parents. So we're talking about almost half of these students also having dependents. And so then when we're also talking about being low income and coming out of these things as students of color, and low income students have the have higher rates of being student parents, not taking into account family composition, not just family size. Again, going back to, if you're a 2-person household, you could be a single parent, or you could be a 2-income earner. If you have a 3-income, you could have 1 child and 2 incomes. And I think considering how that composition is in this is really important when you're designing that program.
Thanks, Michaela. Jennifer.
I just want to say thank you, Michaela, but I also want to I want to get clarification before we go into public comments. That's why I kind of raised my hand early. On the next steps that are on the issues around default that were brought up by Persis. I want to just clarify, will ED be giving a presentation tomorrow morning on the conversation that they're having? Because that's what was mentioned earlier, but we didn't really get a clarification on that. I want to do it now before we go into public comments. Thank you.
I think the clarification that I can add is that I suggested hitting the pause button because David asked perhaps maybe the department wanted to respond on some of the issues or the plan forward on what was raised in Persis's proposal to add additional topics. And instead of rush directly to a consensus check, which may have been to add those, but it may have also been to not add those, to perhaps allow everyone to further consider that, give the department an opportunity to respond if there is a response to be given, and then we could move forward with the consensus check. That was what my thinking was behind the suggestion. Does that address it, Jennifer?
A little bit. So just for clarification, we will be getting those results in the morning. That way we know like where the stance is and what we're doing with them. If that's it, then yes, it's answered. Thank you.
Okay, so Ed, let me ask you, earlier I suggested a pause button because David had asked more clarification perhaps around Ed's perspective on that in terms of moving forward. I wanted to hit the pause button so that you could respond. I don't know that you have a response at this time, but I'm happy to invite it to answer Jennifer's questions.
I mean, all I can say at this point, no, we won't have a presentation available for you all tomorrow. We need to get through all our topics first. So we're very worried about not getting through things like we have false certification. We want to finish this discussion on IDR. We want Raj to kind of share more information with us. We want to get through false certification as well as Pell Grant eligibility for prison education. So, and we further have concerns about the feasibility of at least one of the proposals that has been put forth. And we can't at this point weigh in on it. We know, again, that we are already proposing to do regulations directly related to debt collection, which do not live in the HEA. So we would need several answers on any of those items to discuss them. We're not prepared to do so right now.
Okay, thank you. Joe, the floor is yours.
Yeah, hi. Are we addressing question 6 yet?
Yeah, we are. Yeah, that was introduced.
Okay. So I think that question 6 gets to issues of borrower support. And borrower support is currently provided through servicers. Servicers are supposed to be your information conduit to go to when you have questions about your loans, about issues with repayment, about how to deal with, as question 6 says, student loan struggles. And, what state attorneys general have consistently seen in the student loan servicing space is a lack of the kind of detailed information that borrowers need in order to navigate these systems. And I think that as you have populations that don't have as much experience with consumer financial products and debt generally within their families, the need for that support increases. And so, there are a couple ways to deal with this. One, something that I mentioned that Bethany has certainly brought up is automation and simplicity. One of the things, in the Consumer Fraud Bureau of the Attorney General's office, when we get relief for consumers through a lawsuit or a settlement, we do everything we can to avoid a claims process or any kind of administrative burden. So when you're thinking about question 6, reducing the need for the borrower to take action or to gain information or to make some kind of a choice, I think would help there. The second piece goes to the amount of touch and support that borrowers get. I have had some interesting discussions with the Rhode Island Student Loan Authority. They instituted a state-level income-driven repayment plan, and one of the things that they think made that plan successful is that they took their servicing in-house. And when the servicing is in-house, there's a connection between the profit that the servicer makes and repayment of the loan. So I would encourage the department. I can drop a link into some data on the RISLA program.
Thanks, Joe. I think we have time for probably one more, two more, because I see Noelia and Persis' hands, but I just wanted to quickly recognize some primary folks who are rejoining us. So we have Misty back at the table representing 4-year private institutions, Jerry representing student loan borrowers, and Jessica representing proprietary schools. So with that, Noelia.
Yeah, I want to echo those comments about support, but I think we're also missing the support that universities and schools give their students. I know that many campuses have put in financial wellness programming, financial literacy programming, to really guide students through do you need to borrow? If you do, can you lower how much you're borrowing? And then as they near graduation or they've exited the campuses, walking them through those borrower repayment options, what are some of those loan forgiveness programs that they may qualify for. So I think that campuses and universities and colleges are very important, play an important role to this in really guiding students through that, what happens after I leave campus, whether through graduation or drop out. So.
Thank you, Noelia. And then Persis, I think you are our last committee comment for the day before we open it up to the public.
Thank you. I just want to return to the point that was raised earlier, that if the department is not planning on making a presentation about the proposals that I have motioned to have included, that we then take a consensus check on whether or not those should be included.
Understood. Let me do this. Aaron, would you mind stop sharing your screen very briefly? If we want, we can have more conversation on this tomorrow morning, just because I think it might eat into the public comment period, but I'm willing to just take a thumbs vote right now. But Persis, since you raised it, I'm willing to see what you're interested in doing.
I'm happy to see if there are other folks in the committee who would like to speak to this, in which case I'm happy to defer to tomorrow. But if there is no need for a further conversation, I think you've heard a lot from me. So then I would just love to get everyone on the record on what they think.
So I'm seeing at least one hand up right now. So if it's okay with you, I'm going to call on Daniel, and then we can open up tomorrow's proceedings with this check, if it's okay with you.
I would specifically like to encourage the department to consider Persis's suggestion around using IDR as a recovery method from default if we're not willing to consider the entire piece. It seems to me that it's completely relevant and appropriate given the conversation we're having about restructuring the IDR program. So I would offer support to that piece, if not to the entire piece, which I also support. But at minimum, I see the direct relevance of that particular piece to the conversation we're having.
Jennifer.
Yeah, just to reaffirm, that's always been our stance. To the extent that these proposals are relevant to the discussion we're having, we're happy to hear them.
So with that, why don't we, if we're okay, just opening up tomorrow with that check, because then we can have a full period for public comment, because it is right at 3:30. Can I get thumbs on that? I know consensus check for a consensus check is an annoying thing to ask for. Seeing thumbs, seeing sideways, but no, I do appreciate that, and we will return to this, I promise. So with that, I think we are ready to admit our first person. So Cindy, could you go ahead and admit Brian Whitehead, who is a veteran representing himself? Oh, and I see, oh, there he is. He has to enable his audio. Hi, Mr. Whitehead, can you hear us? Good afternoon, Mr. Whitehead, how are you?
I'm good. How's it going today?
Good, you have 3 minutes, go ahead.
All right. Good afternoon. My name is Brian Whitehead, and I'm from Loganville, Georgia. I served in the U.S. Army from 2000 to 2005. After I left the service, I attended ITT Tech from 2006 to 2008 to study computer and electrical engineering. I graduated from the program, but after almost a year of looking for a job, I was never able to get one in the field that I studied. When the school recruited me, they told me that 90% of its students were were guaranteed jobs right out of the gate, with average salary starting between $60,000 and $70,000 a year. That was not true. And on top of that, I have student loan debt around $50,000 federal and $40,000 in private loans. Even though ITT told me that my GI Bill benefits will cover my entire education. Right now, I have a job because of the skills that I learned in the military, not because of that degree from ITT Tech. Still, it's a job that barely pays the bills, and I have to ask for help from my family and friends. I wanted to complete school to get into a career where I could earn a decent living, but ITT's degrees aren't worth the paper that they're printed on. I had classes taught by people who admitted they weren't qualified to teach computer programming or anything tech related. I know if I had gotten a degree from a more reputable university, along with my military experience, I'd be in a much better place. ITT Tech may be closed, but I have to live with the debt and frustration that they left behind. I wanted to testify here today to ask you to stop schools like ITT Tech so that they can't get away with lying to get veterans to enroll in their schools. They need to be held accountable for their lives because they have the power to destroy our career goals and ruin our lives. Thank you for your time.
Thank you very much for your comment.
I appreciate it.
So next up, if you can let in Amy Leighton, representing New America from the waiting room.
Stop schools like ITT Tech so that they can't get
Oh,
away.
and Amy, I think I'm hearing, you just need to pause the live stream because I think we're going to get a bit of an echo otherwise. Got it. And then whenever you're ready, you have 3 minutes. Ms. Leighton, can you hear us?
Oh, yes, I'm sorry. I thought Bradley was still speaking.
Oh, no, you're okay. You're okay. You have 3 minutes. Go ahead.
Great, thank you. Thank you so much for taking the time for public comment. I wanted to bring up an issue that I was surprised didn't come up yesterday in relation to issue paper number 8 on recovery from institutions. In terms of the issue paper that the department put out, I was frankly surprised to see such a weak opening bid come from the Biden administration, given the promises during the campaign and then in the opening months of the administration to really crack down on predatory colleges in order to prevent real harms to students and borrowers. Borrower defense should have both a back end and a front end function. It should help borrowers who already have been harmed, and it should also prevent future students and borrowers from being harmed. By making it optional for the department to act against a school, if the department has found that a borrower is entitled to relief, this proposal fails to prevent future harm. For current borrowers, all we can really provide is financial relief, but we can't make up for the other harms, real harms they've experienced: lost time, energy, and momentum, and the emotional toll of all of it. We cannot make those borrowers whole, but we can and must try to prevent those significant harms for future borrowers. I agree that students shouldn't have to wait for the department to take action against a school before they get the relief entitled to them, but the department should not have the discretion on whether or not to take action against a school that harmed a student. Predatory schools need to know that accountability is not optional. The proposal as written lets schools off the hook and absolves them of their decisions that harmed students. I'm so glad that this group is trying to strengthen the back-end protections and borrower defense for those who have already been harmed by predatory schools. But I urge you not to be inadvertently complicit in allowing future students and borrowers to be harmed by ignoring the front-end protections. Thank you for all that you're doing, and good luck with the rest of the NAGBRC.
Thank you very much for your comment. So next up, we have Ms. Tricia Purdon, who is the Director for the Office of Rural Prosperity for the Kansas Department of Commerce. And Ms. Purdon, the floor is yours once we get audio and video up and running.
Good afternoon. Thank you so much for having me to speak to the committee. I appreciate it very much. I'm Tricia Purdon. I'm with the Kansas Office of Rural Prosperity in the Kansas Department of Commerce. I'm speaking specifically about rural communities, but this issue that I wanted to bring up to the committee really pertains to both urban and rural. I wanted to speak really referring to issue paper number 5 regarding the department's question seeking ideas on what should be included in the definition of the primary services of a private organization. Specifically, the 3 areas that I wanted the committee to consider is allowing organizations that are not specifically defined in the current descriptions, such as economic development organizations, chambers of commerce, and Main Street organizations, which are often 501c3 organizations, but fully, if not or partially funded by local government or state government organizations. They're often 501c6s because of their need to have private business memberships to cover that fund. However, these organizations are critical pieces of our local economies and often are the linchpins of whether or not a community maintains their rural healthcare facilities, mental health facilities, and often are integral in pieces of public safety, public interest legal services, addressing poverty, and public health issues. It's especially true in rural communities where there's gaps in addressing these issues for communities. And so I would like the committee to consider including these organizations specifically in the guidance, as those are often areas that are confusing in regarding the PSLF program when they're filing the requirements. One of the reasons, if you have difficulty, I thought about including them, is the fact underneath the public interest legal services, it does mention that these legal services are funded whole or in part by a state, local, or federal or tribal government, and these organizations typically are funded in that framework and provide legal services. For example, organizations might fund or assist a small business in filing an LLC or getting an S Corp or C Corp set up. Although they're definitely not attorneys, they assist these businesses in these critical pieces and often case in these rural areas. So with that, thank you very much, committee, for listening to me. We hope that these organizations will be considered, and look forward to hearing the results. Thank you.
Thank you so much for your comment. Next up, we have David Kosienba, and please correct me if I'm pronouncing that incorrectly, who is an East Coast organizer representing the American Association of University Professors. So, Mr. Kosienba, you have the floor for 3 minutes. You just got to mute yourself. There you go.
Good afternoon. My name is David Kochemba. I'm an East Coast organizer for the American Association of University Professors. I was an adjunct professor for 16 years at 5 institutions in the Boston area. I'm not alone in leaving the profession. There's an entire subgenre of quit-lit writing devoted to the phenomenon. For millions of academics like I was, your department and its loan servicers have broken their pledge to recognize those who live a life of public service. 98% of those who have applied have been rejected. While proposals on the table have promise, fundamental changes are needed to address the realities of what 10 years of laboring as an adjunct professor looks like. It's extremely difficult for adjunct professors to have their work recognized by the existing program, though it is heartening to hear from so many negotiators today that you understand this. University administrators make sure that adjunct faculty don't hit the current eligibility threshold, lest the university give them health insurance. So career adjunct faculty cobble together work at multiple universities that's more than full-time work, but just barely 30 hours in state and federal definitions. Earlier today, folks asked for data related to the contingency crisis. Contingent faculty are disproportionately women and racial minorities. 43% are part-time, and based on the AEP's annual survey, are just scraping by on a national average of $3,556 a course. Unfortunately, there isn't a recent or conclusive study on the average adjunct's course load, but a 2010 study estimated it was just shy of 3 classes per academic year. Most get no contributions towards health or retirement and have unemployment so unpredictable, they might not know their own course load a month away from the start of term. Don't let the tweed fool you. Being a college professor is no longer a reliable path to the middle class. I've talked to faculty who needed to file for unemployment, who worked weekends and nights at other jobs, or who wanted to find food pantries where they wouldn't run into their students. The path out of crushing student loan debt should be less onerous for those whose employment is the most precarious. To echo what others have already said at the negotiating table today, go beyond the 2.5 work hours proposed for every credit hour, perhaps by adding on required office hours or by using a more generous conversion rate. Under the current proposal, an adjunct professor would need to teach 4 3-credit courses each semester to qualify for PSLF, despite their full-time peers getting benefits with 1 less course a semester. So-called part-time professors advise students write and do research, and please recognize that most courses are taught during the 9-month academic year when calculating eligibility. And remember faculty like me that are still paying off loans they took out in the 1990s. Thank you for your time.
Thank you, Mr. Kochemba, for your comment. The next commenter we have is Mr. David Mayfield representing himself. So Mr. Mayfield, once we have your sound working, the floor is yours. Mr. Mayfield, can you hear me?
I can hear you now.
Great. If you have video, feel free to turn it on. Otherwise, you have 3 minutes for public comment.
I'm trying to get everything up. All righty, can you see me now?
We can see you and hear you. Go ahead.
All right. So my story with ITT Technical Institute, I was told by the ITT employees that if I attended the school and stayed the course at school, that I could get a 5-figure starting out salary, starting at $55,000 per year. I find that this was not the case, as I couldn't even find a job or get any interviews. And I found out the information that they told me for employment prospecting was very misleading. However, going into what else I was told about the program, that the school was fully funded through my Montgomery GI Bill, my post 9/11, that I wouldn't have any debt at all. I would talk to student counselors to confirm this, and that my GI Bill was 100%, but now I was stuck with federal and private student loans that was taken out in my name. I was misled about the cost and everything that was being financed in addition to that. With career services, ITT told me that I had contacts and they had contacts that will help me to get a job, but I received no phone calls, no interviews from their alleged firms. I had meetings with counselors countless times who told me that I would need to stay the course at ITT Tech to be able to be sought after for the job market, but that was not the case at all as well. I ended up having to get a job as an installer with no help at ITT, and this wasn't even part of my career study. In addition, I would like to share that the professors were mostly graduates to ITT Technical Institute themselves, and these classes were not challenging. And then I will receive a good education that my experience was accredited. But I figured out and found out that these activities they were violations, and it wasn't even applicable for the consumer protection laws. And now I'm stuck with private student loans. As a military service member, as a veteran, I served our country and I stood for honor, courage, and commitment, and I was lied to. And I found that the parity is that we have enemies, the world does. And I served our country to protect our rights from these type of enemies. And yet now I have to worry about some of these things in addition, and where we are, even in the United States of America, where we have to now have falseness in education. And I think that's not right.
Thank you very much for your comment, Mr. Mayfield. The next person coming into the room is from the wait list, and it is Ms. Krista Kirschenheiter representing herself. So if someone could admit her, great. Hi, good afternoon, Ms. Kirschenheiter. Can you hear me?
I can hear you.
All right, you have 3 minutes for public comment, please.
Okay, I'm sorry, I thought you were still speaking. Good afternoon. Hello, sorry.
We can hear you. Sorry about that.
Okay.
You have 3
You
minutes.
can
Go
hear me?
ahead. Yep, we can hear you.
Yes, I can hear you now. Thank you. Hi, good afternoon. Thank you for allowing me to speak before you today. I wanted to introduce myself. My name is Krista Kirschenheiter. I work for legal services, and I've done that for the last 12 years. I want to tell you a little about my experience with the Public Service Loan Forgiveness Program. I have 60 credits to date, even though I have been working in public service for almost 12 years. Sorry, I'm hearing an echo. Let me see if I can change this.
You might have the live stream up. If you're able to pause that,
Yeah,
typically
I
gets
got
rid of
that
it.
out, yes. So I only have 60 credits to date after almost 12 years of working public service, and I've had, my career is working with programs, Social Security, FEMA, VA, for all sorts of people, and this program has been the most complicated, complex, convoluted, and I'm a lawyer, and program I've ever had to deal with. I can tell you that at one point, because my loans were sold to different service providers, I finally had to switch my loan to the Department of Education so that I could get an answer to what qualified, because I didn't know that if I overpaid 1 month, the next month those weren't counting if I underpaid by a few cents. And so when I was switching over for a year, I didn't have any payments during that year. I was put on a deferment, and so that whole year of work didn't count. The first 3 years of my public service, beginning when I was getting earned income tax credit that year as a single mother, my son was on Medicaid, I was getting public service, making myself through. I was paying my loans, but they don't count those because I wasn't in this program. I was through a FEMA disaster, and I needed extra income so I could get out of the disaster, and I had to get a deference, and those months that I didn't make payments didn't count. It's just so hard. I've gone through cycle after cycle of review with the public service loan forgiveness. I think I'm in my 5th. They don't tell you how long these reviews will go. I think right now I've been waiting over a year. Randomly, they give me a month of credit. Oh, here's one that I heard. I was switching legal services job. I worked for my employer until September 27th. My payment was due September 28th. I made my payment on time.
30 seconds.
But because my payment date was 1 day after I quit on a Saturday, they didn't count that month of service and that payment. But if my payment due date had been due September 26th, that month would have counted. And I just want to express my frustration in trying to juggle this program. And I'm really excited that you guys are meeting, because I think the program was supposed to help us, but it really limits our ability to do anything with our careers as we wait, as I'll probably work this public service, not that I mind, but for the next 20 years.
Thank you, Ms. Kirschenheiter, so much for your comment. Thank you very much.
Thank you.
All right, next up we have Ms. Ariel Atherley representing the Leadership Conference on Civil and Human Rights. So we'll give her a moment to get online. Hi, Ms. Atherley, are you in the meeting with us?
I am here.
Hi, welcome. If you're able to turn it, great, fantastic. We can hear you, and you have 3 minutes starting now.
Wonderful, thank you. So thanks so much for having me. My name is Ariel Atherley, and I'm a policy analyst at the Leadership Conference on Civil and Human Rights in Washington, D.C. We are a coalition charged by our diverse membership of more than 220 national organizations to promote and protect the civil and human rights of all persons in the United States. The civil rights community has long recognized equal educational opportunity as central to our struggle to achieve equality for all Americans. And despite some of our nation's most fundamental laws that remove some of the barriers to access for students, Students from marginalized communities continue to be excluded from quality post-secondary education based on their race, their status as a justice impacted person, or their disability status. Institutions of higher education must ensure the right to an equal educational opportunity for all students in America, and federal civil rights laws must be enforced so that campus communities are inclusive of the full diversity of students in America. Without these protections, exclusionary policies and practices will result in a lack of equal opportunity for some of our most marginalized students. As such, we urge the department to consider changes in a number of areas, including what is outlined below. First, on student loan debt cancellation. The rising cost of education has kept post-secondary education out of reach for many low-income students unless they rely heavily on student loans, a choice that Black and Latino students are disproportionately faced with. The $1.7 trillion student loan crisis is crushing individuals, families, and our economy, and the weight of this burden is disproportionately borne by women and Black and Latino borrowers. A debt-financed higher education system in a society defined by dramatic racial, gender, disability, and wealth disparities will always inherently be flawed and inequitable. And though there are established programs intended to make student loan repayment manageable, the impediments to accessing relief have been well documented, and very few borrowers have been successful thus far in obtaining relief through repayment programs. The only solution that addresses the harms of the past is to look towards widespread debt cancellation. And so we're looking to the department to issue guidance that would result in an immediate cancellation of at least $50,000 of student debt per borrower, which would provide relief to millions of borrowers facing the burden of their student loan every day. On gainful employment, in a 2018 brief on the topic of gainful employment, the civil rights community called for a strong gainful employment regulation that protected students and curtailed abusive practices by for-profit institutions. Despite spurious claims to the contrary, for-profit colleges do not serve Black and Latino community, and rather they profit from deep cultural commitments to education and students' belief that the Department of Education would only make financial aid available for worthwhile programs. In the names of these students and their families, we urge the department to robustly enforce the laws and regulations on behalf of marginalized students.
Great, thank you so much for your public comment. Next up, coming in from the waiting room is Miss Ashley Pizzuti, who is a for-profit borrower and organizer for other borrowers from the Brooks Institute. Ms. Pizzuti, can you hear us?
Hi, everyone.
You have 3 minutes for a public comment beginning now.
Great, thank you. Hello, everyone. I am Ashley Pizzuti. I first want to thank those who are in support of giving my voice a seat at the table. It's pretty telling when student loan profiteers still control the narrative. I'm utterly disappointed that our voice is being shut out once again. Jessica Berry, it's pretty obvious to everyone watching stuck in the borrower defense pipeline, you are not working in good faith, but for those who stand to put more students in the same situation. Here's my story. In the last decade, I have been researching how my husband and I ended up with $500,000 in student loan debt after graduating from Brooks in 2005. Easy. We were lied to about job prospects, placement, graduation rates, accreditation, transfer of credits, and you pair that with a recession and capitalized interest, and there you go. In 2015, I started to reach out to others from my school. We are all suffering the same fate. I started to collect data on other Brooks borrowers. Out of 500 borrowers, we collectively hold over $70 million. That's $70 million for just under 500 people, all in student loan debt. This is one tiny CEC-owned school out of many. Like I said before, I applied for borrower defense over 5 years ago. This is my application. It includes administrative and faculty testimony on how my program ran in non-compliance as ACICS looked the other way, emails from admissions reps, several investigations and class actions against Brooks, and a CEC shareholder call transcript stating dividends would be paid by keeping warm bodies in their seats by any means necessary. Yet my application was denied under DeVos for lack of evidence. CEC has been proven to be a bad actor, yet here we are still holding the bag. Our lives are permanently on hold, controlled by this debt, while most of us reach middle and retirement age with little options. I'm happy to share my data with anyone that's interested. Thank you for giving me a chance to speak. I wish it was more.
Thank you, Ms. Pizzuti, for your public comment. Next up, and actually our final public commenter that we currently have in the waiting room is Ms. Keisha Nicholson, representing herself. Ms. Nicholson, can you hear us?
Yes.
Hi, good afternoon. You have 3 minutes for public comment, beginning now.
Hold on. Can you hear me?
I can hear you. Yep, you
Okay.
can hear just fine.
Thank you. Okay. I'm a school psychologist in public service, and I've been doing that for 15 years. I had FFEL undergrad loans and direct grad loans that I consolidated into an FFEL consolidation in 2006. So I'm hopeful that your new guidelines are going to address most of my concerns. But I do have concerns about, do I need to show payments? Because this will be difficult. I already had 2 FOIAs. I've closed my bank account that I had paid from that. So I hope that this will be addressed. Also, if my loans are forgiven, yay, but my family budget will not change. My husband still has loans, so I'll still fall under that marriage penalty, as Bobby had stated in the past. Childcare. When my child was younger, our thing was based on a sliding scale for API. That doesn't acknowledge student debt. So even though we would get raises, our childcare and our student loan payments would also go up. So this is also a problem if people have non-traditional work at night. They rely on family, so you don't know how much they're needing to pay. So Joe's suggestion of pulling the IRS data might not address that group. The loan amount calculated was too high when my husband was in deferment. So it was saying I could, as a family, we could pay this much, but his loans were deferred. So we need a way to calculate when one spouse is in school and paying on their loan, or when one spouse is in school and the other one's paying on their loans. Marjorie had pointed out like the discrepancy of undergrad and grad. For my position, we should have undergrad and grad forgiveness. I would echo that and not have any differences between the two, because for my job, I need to have a master's. I needed to have grad school. Otherwise, I'd kind of be in that position of not really being able to pay my own loans necessarily with just a bachelor's. I echo what people had said about needing more support. People with loans, they need somebody that understands the tax implications, like do they have to do married filed separately? And we also need people that understand the different forgiveness programs, because maybe somebody qualifies better for a teacher forgiveness versus public service loan. I think this would help address the equity issue too for people. Also, alumni support, especially for public university. So just being able to have that connection. And then also people with student loans never get to experience any real increase when they get any kind of raises, because our cost of living goes up and our student loans go up as well. So thank you for allowing me to be part of this today.
Thank you very much for your comment. And actually, I hope no one minds if we go a minute over. We have our final speaker just entered the waiting room. It's Mr. Christopher Lorem representing himself. So Mr. Lorem, can you hear me?
Yes, I can hear you.
Good afternoon. The floor is yours for 3 minutes.
All right, thank you. So I'll keep this pretty brief. I'm definitely glad that this committee is dealing, with some of the hard situations that many out there are facing. Some of my concerns are, however, a little bit more broad, I guess, that the Department of Education, I hope, is considering. My comment would be basically, why is it up that you can go out and buy a house, you can buy a car, and you can even get, private loans for things that aren't education at least a 50% lower interest rate than the federally mandated interest rate that's out there, which is over 5% for some that have even higher than I've heard of 7 all the way up to 12%. Federal student loans, are there to help people who can't afford schooling out of pocket. So they're able to further their quality of life by having the opportunity to have a higher income through jobs that can require higher education. Why is student loan interest capitalized throughout a 4 to 5 year, period of while you're in school. If the economy again is not healthy, there aren't a whole lot of jobs out there to get something quickly after graduation. Why isn't there a 1 year grace period where interest is not being capitalized? One other issue that I'm concerned with is why aren't student loans something that can be something coming out of your paycheck pre-tax, just like many health benefits do? And I think these are fundamental flaws that are aiding in the $1.7 trillion of student loan debt. I hope that on top of all the issues this committee is discussing, that these are problems that are being looked at as part of the solution. Thank you.
Thank you very much for your public comment. All right, that actually ended right on time, I think. That concludes day 4 of week 1 of negotiated rulemaking, and we will see everyone here tomorrow at 10 a.m. Eastern.